Items for pronouncement of judgment. WPC 2653/2023 and WPC 3298/2023.
Repetition allowed. Selection of respondent number 6, then set aside in post.
Wait, please.
Yes.
With consent of the other side, my lord, I beg to mention item number 40, my lord. Last item in the mail list, my lord. Will be taken up next week, my lord, on a hearing day, my lord.
Item number
40, my lord. 40.
you obtain permission
My
for the
lord,
others.
my lord. I have
Mr.
consent.
Sundari, learned counsel for the. Okay. Secretary.
Yes, what is it? I promise. Question, আমি লইলাম আপনি
মাথা।
কি বলা হোক
So when do you want?
My lord, next week, my lord, any hearing day, my lord.
Okay.
in the month of June,
My lord,
3rd June.
my lord.
Okay.
And this to MSc appeal, my lord, like listed in the last year, my lord. Can it be listed next week or day after, thereafter, my lord? Any date, my lord.
Okay.
In the month of June, 1st week of June,
My lord, my lord.
4th and 5th June. Two cases,
2.
4th and 5th.
Much obliged.
Okay.
Yeah, please, your lordship. So I beg to mention
Please,
for
please.
listing.
Mr. Sundari, learned counsel for the appellant with concept on the other side, place for listening the matter on 3rd of June. Pairs that's allowed. Yes.
Lordship, I beg to mention for listing for withdrawal for tomorrow.
When?
Tomorrow, lordship.
Tomorrow other bench.
Okay.
Lordship. May I please, lordship? My lord, I beg to mention for listing, my lord, MSc appeal, my lord, which is pending since 2028. I guess. Sorry.
When do you want? When do you want?
My lord, 3rd June, my lord.
Also,
Oh, listen.
May it please, your lordship.
yes.
Lordship, with the consent of the other side, lordship, I beg to mention item number 41, 42, lordship.
Item number
41 and 42 may kindly be upgraded, lordship. We have
41 and 42.
42, lordship. We have informed SMT 60, lordship.
Okay. Okay.
Upgrade. Time worship at what time? Upgrade.
Lordship.
My lord, I pray for a listing of a motion tomorrow, my lord. There is some urgency because this is a custody battle and a court without jurisdiction on Friday, my lord, the girl child has been asked to be produced, my lord.
Okay.
My lord.
Yeah, please, your lordship. I beg to mention one RSA for listing in the 1st week of June.
When?
My lord, it's a 2016 matter. And earlier 2 dates.
For hearing?
Yes, earlier.
Hearing.
And another one is, my lord,
5th June. 5th June.
Highly obliged. Another one is 198, tag with 201 of 16. This matter earlier 2 days. Highly obliged.
Please, lordship. Lordship, beg to mention item number 14, lordship.
1-4.
1-4, lordship. Thing is that, lordship, the appellant has expired, lordship. We need to substitute him, lordship.
Mr.
MM Zaman, lordship, on behalf of S. Samaria.
MM Jamal, learned counsel appearing on behalf of Mr. S. Samaria, learned counsel for the
Appellant, lordship.
petitioner or appellant?
RFA, lordship.
Okay, appellant. Submits that the appellant.
Yes, lordship.
Appellant suffered demise. Then there is a requirement for implement of the legal heirs of the appellant. And price for granting him some time, there is allowed to recessize the matter after 2 weeks.
4 weeks, lordship.
4 weeks.
Deeply.
Yes.
Doctor, I'd like to mention listing of 2 matters. One is Met appeal and one is FAO. So any date, Lordship.
Under which category? Under which column?
One for orders, Met appeal, and FAO is for admission.
Okay, one on 9th, one on 11th. 9 June, 11 June.
Which one?
Nine.
Obliged.
May I please, your lordship. Your lordship, I beg to mention item number 24. We have taken the concept
20?
for the other side. 24. We have taken the concept for the other side, lordship. So. And this concept is out of station.
You are for
An alarm, respondent one,
Mr.
S.A. Bacteria.
S.A. Bacteria, learned counsel, appearing on behalf of Mr. N. Alam, learned counsel for the applicant, stroke appellant. As for listing the matter after
Any date within this week or next week?
Second,
a week.
after a week,
Uh,
Date, lordship? Date?
second,
Second June.
2nd June.
yes.
May I please,
Much
your
obliged.
lordship, I beg to mention for listing one IA lordship in MSc appeal lordship for withdrawal of 50% deposit amount lordship. It is filed on 22/4 and
When do you want?
next week any date lordship, 26, 27,
Okay.
26.
28, 28 June.
Some default 29.
29.
May I please, your lordship, I'm praying for listing of an RSA method in the stage of hearing.
When?
Any hearing date.
Okay.
On 12 June.
12.
May I please, your lordship, I beg to mention for listing of one IA, your lordship.
Hmm.
For IA for early hearing, it was listed in this honorable court, but notice was issued, your lordship.
Hmm.
The matter may come up for orders, your lordship.
When?
On Saturday, on Friday, your lordship.
Friday.
Monday, next Monday.
Monday, 26th.
Monday. Yes.
Lordship, I beg to mention item number 9. I may be allowed to withdraw, lordship, already petitioner was arrested.
Arrested.
Lordship.
Mr. L.R. Mazumdar, learned counsel for the applicant, submits that the applicant has already been arrested, and as such, this application become infectious, and accordingly, the same instance closed.
Omelette. May I please, your lordship? Lordship, I beg for listing a RSA matter, lordship, in
When?
admission column, lordship, on 26, if possible, lordship, because on 28, lordship, execution date is fixed, lordship.
26. COVID.
26, we have few cases.
Lordship,
On 27th,
lordship, all right.
May I please, your lordship? I beg to mention for listing two MSc appeal. One is for 3 June and another is for 12 June for orders.
May it please, your lordship. Lordship, I beg to mention item number 39, your lordship.
39.
Yes, your lordship. So the consent has already been taken, your lordship. I pray that the matter may be taken up in the month of June, your lordship.
Pardon?
It may be taken up in the month of June, your lordship.
June.
Yes.
Mr. Your good name?
I'm KJ Saikya, your lordship.
Is this Sakya, learned counsel, appearing on behalf of
On behalf of Mr. A.K. Gupta.
A.K. Gupta, learned counsel for the petitioner. You inform the other side.
Yes, your lordship.
With consent from the other side, first for listing the matter in the month of June.
June 28th of June 20.
20.
20 is Friday, hearing case. 24th June, 24.
Lordship, there is another prayer, lordship, for listing of a arbitration appeal, your lordship, for orders.
When?
Lordship, any date, your lordship, next week,
On 4th June.
4th June. 4th June. Your pleasure.
From daily list promotion, item 1.
May it pleases your lordship. Your lordship, this is a revision petition.
Lordship, in the continuation application, we have appeared, but in the CRP, our name has not been shown, my lord. Let them furnish a copy of the CRP and fix the matter on Monday, my lord.
Monday?
Monday, I will not be available. Lordship. Lordship, can it be after 6th,
After 6th of
after
June.
6th of June?
Okay. Heard Mr.
A.I. Ahmed.
A.I. Ahmed, learned counsel for the petitioner, and also heard Miss
That's right.
S. Roy, learned counsel for the respondent. Ms. Roy submits that those he appeared in the condemnation petition. Yet, her name is not reflected in the cause list.
Not.
And also, the copy of this civil revision petition has not been furnished to her. Mr. Ahmed, learned counsel for the petitioner, undertakes to furnish a copy of the petition to Ms. Roy during the course of the day. This is the matter Monday.
Lordship, after
Sorry,
6th,
6th of June.
after 6th,
After 6th, COVID.
Lordship,
13th June.
13th June, deeply obliged.
Items for admission, item 2, part.
My lord, for the timing now.
Item 3, part heard matter.
My lordship.
I have a small prayer. Can this matter be taken on tomorrow, my lord?
Pardon?
Tomorrow, I'm praying for taking up the matter for tomorrow, my lord.
Tomorrow?
If possible,
Tomorrow, this court will not be sitting. Day after tomorrow, probably possible.
right. Any hearing them, my lord.
Hearing that.
Hearing them, my lord.
I speak what part heard matter lordship. Any lordship.
And I have no option on Friday, my lord.
Friday.
On Friday.
Next week,
Thursday, my lord, then next week.
Thursday,
Thursday.
Lordship, if possible, lordship, Tuesday, lordship, next week.
Next,
Tuesday.
I have some, I have some difficulty on Tuesday, that is, then Wednesday? Next Wednesday, I have no option.
Okay, that's agreed by learned advocates of both the parties, basis of this matter on Wednesday.
Yes, lordship.
28.
Obliged.
Item number 5, part heard matter.
Why not this matter, lordship earlier, at length also, that on that last occasion, my lord, in the behest of the standing council, Guwahati University, that was, my lord, again today fixed, but there is a Supreme Court's observation also that to matter to be disposed of as early as possible. It is regarding the, my lord, not issuing the affiliation NOC from by the Guwahati University to start, my lord, BA, B.Ed and BSc B.Ed in the petitioner's college. So that they can get the approval from the NCTE, my lord. So issue is pending since long. They have accepted the money after inspection was satisfied. But in spite of all these things, my lord, they have not issued the NOC. And lordship, my lord, gave the lordship in this page. The first, my lord, we approached to given the SCRT, my lord, for giving our NOC, annexure 1 at page 23, my lord. So in response to our letter, they have inspected our institutions and being satisfied, report was submitted and that report was forwarded to the Director of Higher Education for took necessary actions. And then during the time, my lord, the university also, this annexure 2 at page 24. While later dated 31st May, they have issued, my lord, considered 2-member committee of my lord, inspectors of from the university side to inspect our college as per the, my lord, the guidelines of the affiliation of the university concerned. And on basis of this report submitted by this committee and being satisfied all the things, they have submitted the report before the affiliation.
My lord, before my learned friend going deep into the matter, my lord, an affidavit in opposition is being filed today, my lord, on behalf of the university.
They have already filed.
As per earlier order. Not affidavit in opposition, additional affidavit. As per the direction of this honorable court on the earlier occasion. So along with that affidavit, matter may come up day after tomorrow.
You will be filing the affidavit during the course of the day.
My lord, it's being processed, my lord. So, my lord, I'll have to file, submit a copy to my learned friend also, my lord.
Day after tomorrow.
Day after tomorrow.
No, day after tomorrow, that will not possible, my lord, because it's Friday, my lord. I think that tomorrow that should come.
Tomorrow, my lord.
Tomorrow.
Tomorrow, my
I
lord.
don't have any of it.
Because it is already heard your lordship in length. On not only one time, 2-3 times.
But, Mr. Monto, tomorrow this court will not be sitting.
My lord. Then only day after tomorrow, my lord.
Next week also, this court will be at
The
Itanagar.
difficulty is this, my lord, this matter is pending since long. I am suffering. The money was received in
So I am
2022
releasing the
back.
matter from part heard.
My lord. Yeah, my lord.
Heard Mr. P. Monto, learned counsel for the petition, and Mr. P. Jacob, learned standing counsel for the case, respondent in Guwahati University. And
My lord, on my, not my prayer, my lord, there's on their prayer, my lord. This is that to be reflected, my lord.
okay, yes. Respondent number 3, respondent number 3, Mr. Borua for respondent number 3, and Mr. Borua for respondent number 1. And anybody from NCT, no. Non-appeals for the respondent number
They have
6.
filed their affidavit there, NCT.
Mr. Fukan, learned standing counsel for the respondent in Guwahati University submits that he will be filing an additional affidavit pursuant to order of this court dated 25/4/2025. And he plays for listing the matter tomorrow. Tomorrow. Accordingly, it is provided that the SSL lists the matter tomorrow and the matter is thus released from further
Listed on my lord.
tomorrow.
Motion number 6, pardon matter.
Go to order again. Go to order one. And the third one, agree. Item number 4.
Number 6.
Made please, your lordship. As per the order dated 3/4/25, lordship, they are supposed to file a detailed affidavit, lordship.
Lordship, on the last occasion, we had submitted the instruction, my lord. We had, on the last occasion, if your lordship remembers, we had submitted my lord,
3/4, lordship.
submitted to the 2nd April 2025, my lord. And my lord, in that, my lord, it has been categorically stated regarding the date. Lordship wanted exactly on which date he had, my lord, resumed service, his duties. In that report, my lord, it has been given as 8/3/21. So that was the, my lord, and lordship sees the last order.
Lordship, kindly
Petitioner
tell
was
the
not,
order at 3/4/25.
Lordship will see the last
Everything
order.
will be clear.
Last order petitioner was not present. But my lord, one thing is, we have stated in our affidavit already, my lord. We have already filed our affidavit.
When?
We have filed it on, my lord, 14th of February 2025. At page 40.
There was a direction in the order dated 3/4/2025 to bring on record the instruction you have received.
That is, my lord, we have made, my lord, that we are awaiting that, my lord. Same, but the instructions we have already placed, my lord. That it was a simple thing, my lord, that whether he has joined duty on 8/3/21. So already the report is with your lordship. So that, my lord, for signing, it is not come from signing.
No, you comply with the order of this court dated 3/4/2025.
My lord. Then I'll file my affidavit, my lord. I'm awaiting my, my lord, I've sent my affidavit.
Lord Mr. R. Fukan, learned counsel for the petitioner, and Mr. A. Fukan, learned standing counsel for the respondent in Directorate of Elementary Education, Assam. Mr. Fukan submits that though he was asked to file a detailed affidavit by order dated 3/4/2025, he is still awaiting the instruction from the respondent authorities, and he plays for listing the matter after
1
2
week
weeks.
time.
1 week. We are allowed to list the matter after 1 week.
Obliged, lordship. In this case, the affidavit was to be filed clarifying the word local, my lord, that was used with regard to, my lord, this is with regard to, my lord, appointment of, my lord, school managing committee. The president was selected is from an outside district. He's from my lord, Kokrajhar, where the school belongs to the Dhubri district. Now, the word used in the, my lord, circular is, my lord, local. Now, this person who has been appointed is he's in Kokrajhar district, in another district, but 800 meters from the school, my lord. Therefore, my lord, there's a confusion, my lord. Therefore, they were asked to file an, my lord, affidavit, my lord, as to how they, my lord, understand the term, my lord, local. Because in our RTI reply, we were told, my lord, local has to be within the district. Outside district person cannot be appointed. But the affidavit they have filed, my lord, has taken a contradictory stance, saying that since the person is only 800 meters away from the school, though the person belongs to another district, he can still be appointed. That is where, my lord, the confusion lies, my lord. And lordship had heard the matter also earlier. Now the area, the word local has to be, my lord, defined, my lord. That's why they were asked to, my lord, clarify as to what they understand by the word local, my lord. In fact, there was an earlier direction.
You received any instruction?
Lordship, they have asked, they have prayed for a week's time, your lordship, because we have now returned to the government, your lordship. Because the notification is, it was issued by the government, your lordship. So we have written to them to define the word, the local resident, your lordship. So they have asked for a week's time, your lordship.
Okay. Heard Mr. M. Dr. Learned Counsel for the petitioner and Ms. Musari for the respondents in the Secondary Education Department. Ms. Musari submits that though he was directed to obtain instruction by order dated 9/4/2025. Yet she has not received the same and the respondents pressed for granting 1 week time. Here is accordingly allowed. Rest is a matter of 1 week.
Oblige, your lordship.
Hearing under the 41 rule to 6, sorry, I don't know, 7.
Here, in response to queries of the finance department, our department, secondary department has written to the elementary education regarding the queries of the finance department, but till that it is not coming, my lord. This is the queries made by the finance department, my lord. Since the elementary department is also party here, they may be directly.
Who is appearing for elementary education department?
Elementary, one line, I think. I am calling but not getting them, my lord.
After some time?
Or otherwise, it may come up next week, my lord. I will inform the standing council of the elementary, they will.
Next week.
Next week, my lord, in any date, your lordship.
Heard Mr. Alam,
My lord.
Learned Counsel for the petitioner, and Mr. U. Sharma, Learned Standing Counsel for the respondent in the Secondary Education Department. And Mr. Sharma, you have
AG man, respondent number 3,
respondent number 3.
B shop.
B. Sharma. Mr. U. Sharma, Learned Standing Counsel for the respondents in Secondary Education Department submits that that the Secondary Education Department has written a letter to the Finance Department for their concurrence. And the Finance Department by letter dated 27/5/2024 has written another letter to the Director Elementary Education Assam, raising the following query. Education Department is requested to clarify which, while issuing order dated 38/11/2019, allowing counting of past service of the petitioner towards pensionary benefit as per Assam Service Pension Rule 1969, did DEE take incurrence of finance. Question mark, if not, then why they are coming now to finance department now? And that the reply to the aforesaid letters are being awaited, and Mr. Sharma, as well as in the matter after a week, there is accordingly allowed, places always the matter after a week.
My lord,
Instruction-
date will be continued. Pardon.
Instruction plus some record today by Mr. Q Sharma, shall be part of the record.
Probably lordship will not be there in the next again, it's a part hard method.
Okay, as part of.
So after lordship.
It may be part, my lord. Since your lordship in long time, my lord. Your lordship-
Okay, okay.
Date, my lord.
And to. On.
I'll-
12 June.
Obligement.
At number 10 for hearing under order 41, notice it is.
Wait, please, your lordship.
Yes.
Whether the appeal is directed against the order, judgment and orders passed by the learned appellate court, that your lordship will find at page 68. But before I take your lordship to the judgment, my lord, may I just place the facts? There was an agreement for sale of a land between the appellant and the defendant. And the agreement contained a clause that within a period of 3 months, the balance consideration money should be paid. That was the only clause on which, my lord, an interpretation has been recorded by the courts below, that as if that was the time fixed for performance of the contract. And consequently, my lord,
Whether that agreement is part of the record?
yes, that agreement,
Page
your
number?
lordship will find at page 22. 21 is the opening recitals, page 22, clause 4. Clause 4, your lordships may kindly see. The remaining amount shall be paid. I am reading the first, from the first itself, the terms and conditions. The price of the plot has been fixed at rupees so and so. The total amount of so and so is fixed at rupees so and so. The second party pays rupees 5 lakhs in cash in advance today to the first party. In clause 4, the remaining amount shall be paid by the second party after obtaining necessary sales permission from the concerned authority or within 3 months from today, whichever is earlier. So this was the time stipulated for payment of the consideration money, not for completion of sale. Because after the payment is made, balance consideration is made, then only the question of completion of sale will come on execution of sale deed. But the trial court as well as the learned lower appellate court, they have gone wrong in the sense that they have understood it to be the time of 3 months, they have understood it to be the time stipulated for performance of contract. If your lordship will kindly come to page 74, there the discussion by the lower appellate court is there.
Paragraph numbers?
74.
Paragraph number.
Paragraph number 11. The Limitation Act.
Yes.
The Limitation Act states as follows with regard to the specific performance of contract. Article 54, specific performance of a contract, limitation to bring the suit is 3 years. Limitation begins to run from the date fixed for the performance, or if no such date is fixed when the plaintiff has noticed that the performance is refused. We come under the second part of the Article 54. Because in the agreement, there was only time fixed for payment of the money, no time fixed for payment, no time fixed for execution of the contract. Then Article 55 is the record also quoted here, but the observation your lordship will find at paragraph 12. From the above, it is clear that to bring a suit of specific performance of contract, the limitation is 3 years. The limitation begins to start from the date fixed for the performance. Or if no such date is fixed, when the plaintiff has noticed that performance is refused. In our case at hand, the date of performance was fixed. This is the perversity in the order. In our case at hand, date of performance was fixed as 3 months from the date of execution of the aforesaid agreement. These 3 months, as I have shown to your lordship at page 22, These 3 months was for payment of the consideration money, balance consideration money.
No,
Limit-
usually when the last payment is made, the salary is also executed on that day.
It may not also be, because there are 2-3 things are to be completed. First of all, there has to be sale permission, of which, my lord, there is a reference in clause 4. Now, clause 4 says that after the sale permission comes, or even if the sale permission doesn't come, then you are to execute, you are to pay the balance of consideration money. My lord, sale deed can be executed only after the sale permission is granted by the authorities. So it is not automatic that on the payment of balance of consideration money.
The second part is 3 months.
Right, 3 months from the date of execution of that sale agreement for sale, not the sale deed. If I read out to the page, clause 4 once again, the remaining amount shall be paid by the second party after obtaining necessary sales permission from concerned authority, or within 3 months from today, whichever is earlier. The meaning thereby, even if he doesn't get the sale permission, I have to pay the balance of consideration money.
Within 3 months.
Within 3 months. Now, the sale does not become complete if I pay the balance of consideration money, because completion of sale is dependent on grant of sale permission. And the subsequent clauses also, there is only one clause. The lordship will see, no date and time is fixed for completion of sale. The sale can complete only, my lord, after the sale permission is granted and the sale deed is executed. No time is fixed for execution of the sale deed. But the learned trial court as well as the appellate court, they have gone wrong on the premise that as if this was the time fixed for completion of sale. A plain reading of the clause, my lord, does not give out that impression. Now, if your lordship will kindly come to page 75 again. In our case at hand, the date of performance was fixed. They have confused between the date of performance of the contract and the date of completion of payment by balance of consideration money. So this is the perversity, my lord. And on that count, my lord, the suit has been dismissed. If your lordship will kindly see, the suit contained the prayer for a direction upon them to execute the sale deed. If your lordship will kindly come to page 17, page 13, kindly see the prayer. I am asking for specific performance of a contract, so much so that they have to be directed, because no date of execution of sale deed was fixed. The plaintiff therefore claims for a decree for a direction to the defendants to execute and register a sale deed in favor of the plaintiff in respect of scheduled plot of land and accepting the contracted purchase money less than the amount already paid. Second, decree for a direction to the defendants to execute so and so, so and so. Well, this is consequent to A. And clause C is in the alternative, a decree for refund of the earnest advance amount in the event of the plaintiff's failure to obtain the decree as aforesaid. So in the agreement, my lord, there is no time fixed. And since there was no time fixed, so my lord, this finding is apparently perverse, that it was a date fixed for performance, because in the plain reading, my lord, no meaning work out of that particular clause, that any time for execution of sale deed was fixed. And the defendants filed the application under Order 7, Rule 11 only on the count that suit is beyond limitation. And although the appellate court has recorded a finding that limitation is a mixed question of law and fact, but the appellate court has been guided by this observation to hold that this suit is barred by time. If your lordship will kindly come to the next paragraph, paragraph 16, at page 77.
Yes.
The Honorable Apex Court decided as aforesaid, that is, the limitation is a mixed question of law and facts, because sometimes limitation applicable only after proof of certain facts. In such cases, it is mixed question of law and facts. But in our case in hand, the plaintiff itself clarifies that the claim of the appellant is time barred. Now, where from this finding is generated, my lord, that is beyond comprehension. Because all that I say in the plain and the document, from the document, it is a time limit fixed for payment of consideration money. Not time limit fixed for payment of, not time limit fixed for completion of sale or execution of sale deed. Your lordship knows, my lord, the sale deed can be executed only after the permission is granted by the authority.
That's all right.
Without permission, my lord, I cannot go for execution of sale. The clause 4 only says that you are to make the payment of balance consideration money either within 3 months or after completion of, after obtaining the sales permission, whichever is earlier. Meaning thereby, if the grant of permission is delayed beyond 3 months, in that case also I have to make the payment. So therefore, in no circumstance, my lord, question of execution of sale deed comes immediately on the payment of consideration money. That is the simple case. And when I sent the notice to them, in the notice also, my lord, if your lordship will kindly come to page 25, the reply of the notice that we got from the defendant. They also agree on this point that the purport of the clause is this. If your lordship will kindly come to page 25, second paragraph, paragraph A, about 4th line from below. It was agreed between the parties to the agreement dated so and so that a sum of so and so only would be paid on the date of execution of the aforesaid agreement. And the balance amount would be paid by your client after obtaining necessary sale permission from the concerned authority or within 3 months from the date of execution of the agreement, whichever was earlier. So this was also an admitted position by them, that it is only with regard to the payment of the balance of consideration money.
So, do you have any decision in respect of if there is no stipulation of time in the?
Well, the Article 55, which the learned appellate court has quoted in the paragraph 11, my lord, that itself shows that, my lord, if no time for specific, no time for performance is
Paragraph
fixed.
number?
Paragraph number 11, page 74. Article 54 of the Limitation Act, my lord. For specific performance, the limitation begins to run from the date fixed for performance. Or if no such date is fixed, then when the plaintiff has noticed that performance is refused. So naturally, our case was in the second part, that since there is no date fixed for performance of the execution of sale deed, so naturally it will come from the time when the execution is refused. We sent a notice to the defendants. The defendants replied saying that their reply is only on the point that I am not ready and willing to perform my part of contract, and therefore the specific performance will not arise. That is their reply. If your lordship will kindly see in page 26. Well, in a suit for specific performance, my lord, I am only to show my readiness and willingness. And of course, my lord, I am to come within the time stipulated. Now they are disputing in page 26, their reply to my notice, my lord. In page 26, they say that I am not ready and willing to perform the contract. Now, if I am not, whether or not I am willing or ready to perform my part of contract, that will come only in the evidence. Page 26, your lordship will see the agreement for sale of lot of land so and so was executed on so and so, and until the date of notice dated so and so, that is the notice which I sent to them, your client has failed to show his readiness and willingness to perform his part of contract for the purpose of immovable property of my client. So they are disputing only on this count that I am not ready and willing. Whether I am ready and willing, my lord, that I can establish only during the evidence. Because in my plaint, I have stated on which of the occasions, my lord, I approached them, asking them to perform their part of the contract, but they refused. So those statements are there in the plaint, which can be proved only during the course of evidence. So, my lord, this assumption by the learned courts below that the time limit prescribed for completion of the balance consideration money will also become the time specified for performance of contract. In my respectful submission, my lord, that is wrong. Apparently wrong, my lord. The agreement does not disclose any date for performance of the contract.
So in the third suggested substantial question of law, there is a reference to law laid down by Supreme Court. In
Yes, ma'am.
which law? Which law?
That is, my lord. There are two decisions, my lord, where, my lord, the Honorable Supreme Court has said that in a case of this nature, my lord, the time has not to be understood as an essence of the contract. If your lordship will kindly see 2004 8 SCC page, has your lordship got it, my lord? The paragraph number 12. Paragraph number 12 will be at page 694. That time is presumed not to be of the essence of the contract relating to immovable property, but it is of the essence in contracts of reconvenience or renewal of lease. The onus to plead and prove that time was the essence of the contract is on the person alleging it, thus giving an opportunity to the other side to adduce rebuttal evidence that time was not of essence. So if this is to be followed, my lord, in that case, it has to go for a trial. And interestingly, my lord, the defendants also did not say that time is the essence of contract in this case, or any date of performance was fixed. That is also not the case of the defendants. That when the plaintiff pleads that time was not of essence and the defendant does not deny it by evidence, the court is bound to accept the plea of the plaintiff. In cases where notice is given making time of essence, it is the duty of the court to examine the real intention of the party giving such notice by looking at the facts and circumstances of each case, that a vendor has no right to make time of the essence unless he is ready and willing to proceed to completion. And secondly, when the vendor purports to make time of the essence, the purchaser must be guilty of such gross default as to entitle the vendor to rescind the contract. Now here, before the appellate court also, my lord, we submitted the authorities. Absolutely no discussion as to why this judgment will not be applicable. If your lordship will kindly see page 74 once again, just before the learned court starts to giving reason, my lord, paragraph 10, my lord, these decisions were cited. Page 74, paragraph 10. The decisions were cited. Why these decisions are not applicable? Absolutely no discussion. No reference at all. So, my lord, my respectful submission is that, and the other judgment also, there is another judgment that your lordship, my lord, I have submitted there. The relevant paragraphs will be paragraph 9 and 11, repeating the same well accepted principle, my lord. Now, in paragraph 9, the next judgment, my lord, page 467. There also a question of obtaining sale permission was involved. In order to find an answer to the above questions, it would be useful to refer to the relevant recitals from the agreement of sale. Para 3 of the agreement specifically mentions the details of the land sought to be sold, such as extent and boundaries. It also refers the easement rights and the period in which the sale has to be completed. Now, there was a reference of the particular period within which the sale is to be completed. In my case, my lord, it is further better because of the fact that no time for completion of sale is indicated. The recital reads as under: from the total consideration, I have received rupees so and so as an earnest money, of which no independent receipt is necessary. Rest of the amount is to be paid by you at the time of sale deed of the said lands. It is agreed between the parties that the sale deed is to be executed within 6 months from today. Your lordship will find that in my agreement, my lord, there is no disclosure of the kind that within a specified time, my lord, it has to be executed. Possession of the land is to be handed over at the time of sale deed. It is also relevant to mention the default clause which reads as under, for completion of the sale deed, the permission is required to be obtained by me. If I fail to execute the sale deed within stipulated time period, then you have to get it executed on the basis of this agreement. On the contrary, if you fail to get executed the sale deed, then this agreement is supposed to be cancelled and earnest amount will be forfeited. The land is free from all sorts of encumbrances. This agreement is binding on myself and my legal heirs dated so and so and so. The above mentioned details in the agreement of sale clearly show that the subject matter of the property is an agricultural immovable property. The sale deed is to be executed within 6 months from the date of sale. Possession of the land to be handed over at the time of execution of sale, and on failure to get executed the sale deed, the earnest money will be forfeited. With these factual details, let us consider the legal principles enunciated by this court. In so and so, a constitution bench of this court has held that in the sale of immovable property, time is not the essence of the contract. It is now, my lord, that judgment is quoted. Similar is the decision, my lord, which I have read out to your lordship first. Both these cases were referred to before the learned appellate court, my lord. But there is absolutely no discussion, no reference on to these points. So therefore, my lord, my respectful submission is that your lordships will kindly admit the appeal and issue notice. The second case, item number 11 is also buy-in between the same parties, my lord. These are two plots of land contiguous to each other. Two agreements were executed. This is the first agreement. The second agreement is in the second case. Exactly same. And the orders are also of the same date. Only the difference is in the date of the agreement.
Okay, we will go through the same and we will pass the order.
And my lord, we have filed the IA, my lord. There are two IA in both the appeals, my lord.
IFO?
IA4, my lord, and order of injunction, my lord. During pendency of the appeal, my lord, if the nature and character of the suit land is changed, I mean the transfer, if it is transferred to or the third party right is inducted, my lord, in that case, it will involve multiplicity of proceeding.
Okay, we'll see.
So that there are two separate miscellaneous cases in both these appeals, my lord. Oh,
We'll pass the order.
obliged.
Item 12.
May I please, Your Lordship?
Before starting my learned friend, I want to point out that the respondent number 4, Ajit Singh, died on 26, 2017. Respondent number 4. And his heir share is not included.
You will give me the details, I will make the representation.
And he was died during the pendency of the suit.
When the judgment was declared,
Judgment was passed 2012-2019.
whether it was pointed out to the learned courts, you know?
That was actually, I am not sure. But in the second appeal, they informed us that the respondent number 4 died on 26, 2007.
Then what to do? What to do?
Lordship, I will,
They have to implement.
I will make the necessary substitution. My learned friend supplied the.
Before admitting the matter? Before admitting this RSA?
Yes, yes.
Or after?
No, this appeal cannot be admitted because his heir share is not in the memo of appeal.
You file substitution petition then.
Lordship.
Heard, Mr.
Yes.
A. Islam, learned counsel for the appellant, and Mr. A.C. Sharma, learned senior counsel assisted by Mr. Bhardas, learned counsel for the respondent. Mr. A.C. Sharma, learned senior counsel for the respondent, pointed out that during the pendency of the suit before the learned trial court, respondent number 4 herein suffered demise in the year 2017. So that's a. At this instance, Mr. Islam submits that he will file a petition for substitution of the legal heirs of the respondent number 4. That price for granting him some time, there is allowed, rest is the matter. After 2 weeks or 1 week.
My lord, my learned brother may be directed to furnish me the necessary information.
That I cannot, my lord. I have not, there is no contact with the respondent number 4.
Can you collect the information from other respondents?
Well, let them try, and I also make some endeavor to collect the names. Let them try. It is the duty of the appellant to get the substitution.
As per lordship order.
Let them try.
It is the
I
duty
also
of.
make an endeavor to collect the names.
Okay. In the meantime, Mr. S. Sharma, learned a senior counsel for the respondent. Will make an endeavor to collect the particulars of respondent number 4 and furnish the same to Mr. Islam. Within 1 week or 2 weeks.
1
week. Based after 1 week.
Obliged. Upgraded items 41 and 42 per meter.
Lordship on 19.5 Lordship, my learned friend produced a communication Lordship for provincialization of the service of the contempt petitioner Lordship. But there was a mistake Lordship. So
regarding the contempt matter, it has complied, my lord, and Umar has been provincial service of the Umar has been provincialized as tutor, and it is effective from 1/1/2021.
Okay. Lordship, may I submit on? Lordship, I have read the Lordship. The inspector of school DDC Dhubri will verify the service particulars along with all related original documents of the tutor concerned prior to so and so proposal for area salary Lordship. Sir, Lordship, for simple typographical mistake in their part, I am suffering since 2005 Lordship, 2021 Lordship. Lordship may kindly keep it pending Lordship. Keep the contempt matter pending Lordship.
This matter?
Lordship.
No, they have already complied with the order.
No, Lordship, the order Lordship, page 47 Lordship, kindly be patient for a moment. It starts from page 47, now 48. Paragraph 20. Let me read.
Paragraph number 20?
20, Lordship.
Okay.
The petitioner would be entitled to pay an allowances with effect from 1/2/2021. Later it is clarified that 1/1/2021. And the same would now be computed and released to the petitioner by the Director of Secondary Education, Assam. Lordship, keep it pending such that
in the order itself, it is reflected. The petitioner Umar Sheikh is hereby provincialized as assistant teacher tutor in the Balisar High School under Dhubri district with effect from 1/1/2021 as per the provisions of section 21 and 22 Assam Education Provincialization Services Act 2017 as amended 2009.
So now one proposal has to be submitted for area salary. This clause number, terms and condition number 1.
Yes.
So,
And Lordship, few days ago, Lordship, they have independently verified the service particulars of the petitioner. A few days ago, again, they are seeking this report from the IS Lordship.
No, my lord, this order is passed by the director, and the director, as per condition that the inspector has, it is a duty to verify all these documents, whether it is all right or not.
Lordship, I am open to verification, no problem. Only thing is that they may take undue time, Lordship. That is my apprehension, Lordship. So,
But his service is already provincialized as per this order.
no, this verification is for submission of the proposal for area salary.
Lordship.
Yes.
Lordship, since the other matter, writ petition one, Lordship, these two are similar matter, Lordship. That matter, Lordship may kindly peruse flag, green flag, Lordship, in the contempt matter, Lordship. Green flag. In the contempt matter, Lordship.
Contempt matter?
Contempt matter,
Yes.
before your Lordship.
Yes,
Green
yes.
flag may kindly be perused.
Pardon?
Communication dated 4/4/2025, Lordship.
Yes.
Lordship will get that in that communication, they processed for provincialization of service of both the petitioner in this 41 and 42 Lordship together. But now they have come with the 41 petitioner Lordship, item number 41, and 42 is not processing Lordship.
My lord, regarding the writ petition of the Abdul Gofur, it is under process, my lord. Here is my instruction.
And in the writ petition also, Lordship, there's two communication dated 1/5/2025 and 9/1/2025. Those are also in green flag, Lordship. Your Lordship's file.
Here, my lord, proposal for Abdul Gofur has been forwarded to the Government Department of School Education, file letter number so and so, dated so and so. And said proposal was processed and submitted to the Finance Department by the government in the Department of School Education for necessary concurrence. And as the Finance Department is the competent authority in the matter related to provincialization, therefore, upon receipt of concurrence from the Finance Department, further necessary action will be initiated.
Lordship,
This is in the writ petition.
Yes,
writ petition.
it is relating to.
Because they have
We are
processed
not
to the-
disposing of the writ petition. to
Yes.
us. But on the basis of this order,
Lordship,
since your service has been provincialized,
Lordship.
and since there is a direction for submission of the proposal for area
Lordship.
salary, let us close this contempt.
Lordship, instead of closing Lordship, since the matter is parted before your Lordship, since let the matter come along with the writ petition on the next date, Lordship. In the meantime, let us, your Lordship will take instruction from them what about the status of that proposal. to be
My lord,
submitted by the
repetition
IS.
is totally different matter and contempt matter is totally different matter. And
Lordship,
contempt matter already complied. An order has been passed, my lord. It may be closed, my lord. Regarding the
Lordship,
repetition, it may be
direction
there.
is to pay me the allowance, pay salary and allowances. I have shown para 20 Lordship. I have not got that salary and allowances. So Lordship,
This as per this terms and condition number
Lordship,
one, after verification, they will pay it.
Lordship.
There is a process, they have to submit a proposal.
Since your Lordship, matter is parted before your Lordship. So one date may kindly be seen Lordship as to what they come up with. On the next date, Lordship may consider Lordship. Because if it is Lordship closes,
Mr.
then
Sharma, you ask the inspector to
Lordship.
complete the process as soon as practicable.
Yes.
Third, Mr. R. Islam, learned counsel for the petitioner. And Mr. Q. Sharma, learned standing counsel, learned counsel for the respondent contempt. Mr. Sharma has produced an order issued by the Director of Secondary Education, Assam, dated 28/5/2025, stating that necessary correction in the earlier order has been made, and the service of the petitioner, the service of the petitioner hearing is provincialized with effect from 1/1/2021. So Sharma further pointed out that there is a direction in the aforementioned order to the inspector of school DDC Dhubri for verification of the service particulars along with the related original document. And prior to submission of the proposal for arrear salary with effect from 1/1/21. Mr. Islam, learned counsel for the petitioner, submits that there's a contempt matter, maybe kept as further for some time, so that the respondent authorities complete the process of verification of the particulars and make payment of the arrear salary of the petitioner. Taking note of the submission of learned counsel over the parties, the matter is kept as further, and in the meantime, Mr. Sorma, learned counsel for the contempt law, shall inform the inspector of school DDC Doguri to expedite the process of verification of the original document of the petitioner and to submit the proposal for arrear salary with effect from 1/1/2021. As soon as practicable. List the matter after 2 weeks.
Lordship, on 9th, Lordship, some part of already fixed, Lordship, 9th of June, Lordship. Lordship. And another thing is that in the writ petition, Lordship, a writ petition, Lordship, green flag may kindly be seen, Lordship, communication dated 1/5/2025. Order dated 6/5 written there in the top, Lordship. Lordship will get that this communication process for both the petitioner has been processed together, Lordship. May kindly, I do not have that copy, but I have seen from the. But now they are isolating the petitioner of item number 41 and 42.
Maybe, but it does not mean that thereby they have rejected your case.
Lordship. Some direction may kindly be perused, Lordship. Otherwise, also earlier, by order dated, Lordship, 21/6, Lordship, and 9/8/2024, this honorable court strictly directed them to
My
issue
lord,
necessary
instruction dated 1/5/2025 is in the bunch of papers I have already submitted before.
That is there with the
Lordship.
records. Green flag, Lordship.
Whether finance department is a party here.
Finance department is not a party, but your Lordship directed Mr. A. Solia to, I have to check it, Lordship.
Mr. Solia is available.
Yes,
Yes,
Solia.
Lordship. I may call him. I will call him.
You may call.
Yes, he is there.
Madam, can you obtain instruction in respect of one file pending in the finance department? Heard Mr. Islam, learned counsel for the petitioner, and also heard Mr. Yusorma, learned standing counsel for the respondent in secondary education department. Mr. Sorma, learned standing counsel for the secondary education department, has produced the written instruction received by him from the respondent, director in secondary education, where it is stated that proposal for creation of the post of tutor in respect of the petitioner Abdul Ghaffur has been forwarded to the government in Department of School Education. Office letter number E-521-417/28 dated 1/5/2025, and the said proposal was processed and submitted to the finance department by the government in Department of School Education for necessary concurrence. As the finance department is the competent authority in the matter relating to provincialization. And after receipt of concurrence from the finance department, necessary action will be initiated. Mr. Sorma submits that since the process has already been initiated, the matter may be listed after 2 weeks or on the same day, 9th.
On the same day, 9th.
On 9th of June. In the meantime, Ms. Borua, learned Standing counsel for the finance department who is present in the court in respect of some other matters is requested to obtain up to date status of the office letter number so and so dated so and so. And to apprise this court on next date. 9th of June. This shall also reflect the name of Ms. Borua in the cause list on next date.
Lordship, one more prayer, Lordship. My order dated 28/4 passed in this writ petition. The writ petition was made part heard for admission, Lordship. But subsequently it is listed for orders along with contempt. So let the matter come for admission, Lordship.
Which matter?
These two matters. 28/4, Lordship made it part heard, the writ petition.
Whether service completed in this?
Lordship,
Completed.
Lordship. Mr. Amjad had appeared for response.
Mr. Islam learned counsel for the petitioner submits that as services completed in this matter. This matter may be listed for admission hearing along with the contempt petition. Next thing. There stands a lot of resistance will do the needful in this regard. The instruction produced by Mr. Sharma before the court today shall be part of the report.
And the matter is part heard.
Okay, part of.
Item number 10 for orders. Item 10.
None appears for the petitioner on call is the matter of 1 week.
Item 13.
You for the respondent.
Yes, Lordship, for respondent number 4, 5, 7, and 9.
I'm sorry, my lord. I am for the J. Ahmed, Lordship. On behalf of J. Ahmed, Lordship, he is not in the case, Lordship. But his name may be put down, Lordship. Lordship, Mr. A. N. Ahmed will lead, Lordship, this case, Lordship.
Okay. Heard Mr.
A. Hawk, Lordship.
A.
Hawk.
Locker.
A. Hawk.
A. Hawk, learned counsel for the appellate. And Miss
Miss D. Bora.
D. Bora for
5, 7, and 9.
respondent number 4, 5, 7, and
9.
7 and 9.
1 or 1, 2, and 3.
And Madam Borman for respondent number 1, 2, and 3. Mr. Hawk submits that though the name of Mr. J. Ahmed is reflected in the cause list.
J. Ahmed and S. Kulita, Lordship.
S. Kolita is reflected in the cause list. Yeah. They have returned the file.
Yes, Lordship.
They have returned the file to the appellant hearing. And and as such, their name may be deleted from the cause list. There is accordingly allowed recessal issue notice to the appellant. Fixing the matter after 2 weeks.
Obliged, Lordship.
Item 15.
Please, your lordship. Lordship, may grant us one more chance to take steps upon the respondent matter. Clients actually, they were not contacting with us. There was no contact with the appellants, my lord. But recently they have contacted us and they have, so we need one more time, one more date to take steps, my lord. Upon the, otherwise we have taken step, but last occasion, we didn't.
Heard Mr. Dekka, learned counsel for the appellant. Mr. Dekka submits that he will take a first step upon the respondent.
Yes.
There is allowed to resist step be taken by registered also with ADM, also by usual process within a week for today. This is the matter of 4 weeks.
Okay.
Item 16.
Hey, please, Lordship. In this case, Lordship, respondent number 1 died, and accordingly, the appellant has filed petition for substitution of the legal heirs. I am appearing, actually, I am appearing for respondent number 1, 2, and 3. 2 is the wife of respondent number 1. So on the last day, Lordship, this honorable court has directed me to get instruction whether I can appear on behalf of the substituted legal heirs for respondent number 1. I have a number, Lordship. I will try to contact in that number, but that number is of some relatives of respondent number 2. So he did not answer me properly. So accordingly, I sent a letter to the respondent number 2, and that respond according to consignment checking report. That letter was received by the respondent number 2 yesterday, Lordship. So this is the status, Lordship. I have not get any instruction till that from respondent number 2, Lordship.
If earlier on respondent number 1, Lordship, on legal heirs, step has been taken, services were completed, except one Roman 3, that is AD unserved, not AD unserved reciprocity. Okay, all are office note dated 20/12/2023. Service upon all the respondents has been completed, except one Roman 3.
Office not dated
20/12/2023. 20/12/2023. Step has been taken long back.
So you have the instruction to appear on behalf of respondent number 1, 2, and 3.
Originally, I was appearing for respondent number 1, 2, and 3.
Yes.
2 and 3 still there, Lordship, but
One is
one expired, so they have substituted.
One expired, 2 is the wife of 1, Lordship.
what to do?
Lordship may direct them to, Lordship may proceed with expertise against the respondent who have received the notice for substitution petition, Lordship. And for respondent number 1,
1 within Roman 3.
they may take case step, Lordship. Otherwise, I have no other options. I have
About respondent number 1.
1 Roman 3.
There are 1 within bracket Roman 1 to 110, Lordship. 1 3 is not complete. A report has come that unserved AD card received, Lordship. That may be presumed to receive the notice, Lordship.
Unserved.
Unserved.
So you take press system then.
Yes.
Or Mr. Polita, learn for the
B Polita, Lordship.
learned counsel for the appellant, and Mr. A.D. Sodore, learned counsel for the respondent number 2 and 3. Mr. Colita submits that he was directed to obtain instruction as to whether he can appear on behalf of respondent number 1, 3. 1, 3.
One substituted legal heirs of respondent number 1.
Respondent number
1.
Respondent number 1. Respondent number 1. But he could not succeed in the process. Then he submits that the petitioner may take traces upon the respondent number 1. Further, taking note of the submission of learned counsel for both the parties, it is provided that the learned counsel for the appellant shall take traces upon respondent number 1 by registered post with AD and also by usual process. We can now come to that.
1 3, Lordship. 1 3.
1 3. Okay. List the matter after 3 weeks. After 3 weeks.
Complete.
17.
Wait, please, your lordship. Your lordship, service is complete. However, no one has appeared for the respondents.
Is I is for what purpose?
For delay, your lordship. There is a delay of 1829 days. Lordship, in this matter, the respondent expired. So in order to substitute in with his legal heirs, there was a delay of 1829 days. Your lordship can give another last chance for the respondents to appear.
Or Mr. S. Dr. Learned Counsel for the petitioner. None appears for the respondents. So as per order dated 7/8/2024, service upon the respondents number R1, within bracket Roman 1 to R1, within bracket Roman 5 is complete. List the matter after 1 week. In the meantime, the registrar put up an up-to-date office note indicating whether any counsel entered appearance on behalf of the respondents, aforesaid respondents by filing any colored number or not. List the matter after 1 week.
Much of it.
Comes 18 and 19.
Where please, lordship, in this case, lordship, yesterday I have filed the objection, lordship, against the state, lordship. So let the matter may set them up in the next week, lordship,
Along with
objection, lordship.
objection.
Yes, sir.
Lordship,
Read.
in 19, I'm appearing, lordship. I haven't yet received the memo of appeal. And lordship, next week I'll have difficulty for 3 weeks, lordship. I will be out of station. So lordship, maybe on 16th June, the matter can be.
16th of
Yes, lordship.
June.
June, yes, sir. I'll be back then. And in the meantime, memo of appeal can be served on us for item 19. lordship.
So secretary, you have extra copy of memo of appeal.
I will supply.
Or Mr. Secretary, Learned Counsel for the appellant. Then Ms. D. Gorman,
For
Learned
respondent,
Counsel for respondent number 1.
no respondent, only one respondent, lordship. So
And Madam, you are from?
In item 19, lordship. In 18, she's there. In
Okay,
19,
okay. Ms. Gorman submits that. She has filed an objection. And she pressed for listing the matter along with the objection. After on
On 16th. lordship.
16th.
You are
June.
cool.
Or Mr. Secretary, you are in this item number 19 also.
Yes.
Mr.
Same matter, same subject matter. my lord.
Learned Counsel for
Same
the
incident.
appellant. Then Ms. R.D. Mazumdar, Learned Counsel for the respondent. Ms. Mazumdar submits that she has not received the memo of appeal, and as such, she pressed for issuing direction to the appellant to furnish a copy of the memo of appeal to her. Mr. Secretary undertakes to furnish a copy of the memo of appeal to Ms. Mazumdar during the course of the day. Course of the day. Registrar lists the matter on 16/6/2025. Oh, hearing on that day?
Lordship.
Yes, the lordship, I think it
Because-
will
because-
come orders. In
No.
one
The
petition, in
otherwise-
18 lordship, he has filed a petition. In 19, he has not filed any petition.
No,
Since both the cases are coming together, it will come
Since,
for orders.
on 16 lordship make it hearing, my lord, only the limited issue, the regarding remanding of the matter, my lord, that's issue. Only remanding of the matter, my lord. Because only on the basis of the deceased wife, the PW1, the whole case has been closed, my lord. And she was at home. And how she has seen the incident, and on the basis of her statement, whole cases have been disposed of. How can it be possible, man? A person sitting at home can say about the incident.
Okay, even if we list the matter in the order column, we can hear the matter.
Yes. Or else Lordship can fix it for hearing. I do not have any.
Yes, Lordship will fix the hearing.
That is Monday, Lordship.
Hearing.
16th is Monday.
Okay,
Tuesday,
16th is
then
Monday.
17.
Lordship.
That's why I said. Hello, outline.
Always Lordship.
20. Lordship, may I please, Lordship? Lordship, I am appearing on behalf of my senior A. Chaudhary, Lordship. Lordship, in this case, appeal has been already been admitted and substantial question has been framed. And Lordship, notice has been served to all the defendants, Lordship.
So you are appearing
1, 2, 3, and 6, my lord.
1, 2, 3, and 6.
6.
In respect of other respondents,
As per office note, my lord, service complete in respect of respondent number 4 and respondent number 5 has expired, my lord.
service on all the respondents completed. Heard me, sir? Learned counsel for the appellant. And Mr.
AHMR Chaudhary.
Lordship, if LC has been received.
Chaudhary, learned counsel for the respondent number 1, 2, 3, and 6.
Yes, sir.
1, 2, 3, and 6. Office note dated 9/5/2022 indicates that service upon all the respondents completed. But it appears that the respondent number 5 expired.
Yes, sir.
So you have to take a step for implement of the legal heirs.
That is the worst matter. This matter is my junior matter. I wanted to matter. So far as the respondent was she is from same family, other relatives are actually on the party. We will not substitute, not necessary matter. In respect of this case, matter.
As per order dated 9/5/20, no, as per office note dated 9/5/2025. Service upon respondent number 4 completed, but respondent number 4 remain unrepresented today. The same office note also indicates that respondent number 5 suffered demise. Mr. Chaudhary, AU Chaudhary, learned counsel for the appellant submits that respondent number 5 belongs to the same family and the appellant will not implicate the legal heirs. No, there is no necessity of implicating the legal heirs of respondent number 5 in this appeal. Said office note also indicates that the LCR has already been received. In view of above, it is provided that recessal is the matter for hearing in usual course.
No, my lord. My lord, this issue is very small in this case because the appeal was decided in my favor, my lord. Only thing, my lord, obstruction from the road, that word is not there. Has not been cleared, my lord. The road has been allowed.
No, on the day of hearing, we will consider the matter.
Yes. Short date, my lord, maybe in the July, in the month of
No,
July.
no, in usual course, this is of 2024 matter.
No, my lord, originally there were limitation, petition was there, filed in 19, my lord. There was a delay confirmation was there, my lord. It was registered in 24
After 4 weeks then. After 4 weeks.
My lord.
Obliged.
21.
Maybe, Lordship. Lordship, in this matter, service complete, Lordship. Service is complete, Lordship.
Service completed.
LCR has been received. Matter may come on for hearing.
Okay, heard me, sir.
Be ready, Lordship.
Learned counsel for the appellant and Mr.
AI Ahmed,
AI
Contact number 1 and 2.
for the respondent. It is submitted at the bar that service completed and LCR has also been received. And the matter is ready for hearing. Accordingly, it is provided that recessal is the matter for hearing after 4 weeks.
Deeply obliged. 22.
is for restoration of appeal. So my appeal was dismissed for default.
Why you could not appear on that day?
That's it.
Any objection?
Okay, I have filed our objection, Lordship.
When?
In appearing for the respondent number 1, Lordship.
And that's all right. When you have filed your objection?
Lordship.
It's not on record.
Lordship, kindly see para number 5, 6, Lordship.
No, objection matter.
You have not filed objection.
Lordship, it is not record, Lordship. You kindly wait for him. Call for the record.
You have not filed yet.
We have filed. Copy is not there. with-
Okay. Heard Mr. K.K. Bhatt, learned counsel for the applicant. This interlocutory application is preferred by the applicant stroke appellant for restoration of MSc appeal number 253 of 2020, which was dismissed for non-prosecution by the order dated 28/8/2024. Miss, your good name, please.
P. Shah.
Learned counsel for the respondent submits that she may be granted some time to file the objection. There is accordingly allowed recessal is the method. After one.
Already they have filed objection.
Already I have filed.
No, it is not in the system. You go to the section and inquire why it is not listed.
23.
May it please the loss. My lord, the appellant number 1, Abdul Malik died, my lord, on 31/8/2022, my lord. So there is a delay of 257 days for taking steps for substitution. In respects, I filed 3 applications. One for condonation of delay, then setting aside abatement, and also for substitution. So my lord, my learned friend had received the notice and he had appeared. Now, as per our discussion, they have no objection.
Okay. Heard Mr. M.S. Mazhar Bhuiyan, learned counsel for the applicant of appellant. And also heard Mr.
Yes, not.
S.
Not.
S. Not a learned counsel for the
On behalf of
respondent.
Mr. Jadas, I am not in.
He is appearing on behalf of Mr. Jadas, who is.
Okay.
Who is well, man.
I am not learned counsel appearing on behalf of Mr. Zedas, learned counsel for the respondent number.
All the respondents.
All the respondents. This application is preferred by the applicant for condonation of delay of 254 days.
257 days, man. Proper rightly calculated later on.
But in the order, it is reflected as 254 days.
My lord.
There is some
Oh, yeah,
discrepancy in
yes.
your application. In paragraph number 3 and 6, you have mentioned it as 254 days. And in paragraph number 7, you have mentioned it as 314 days.
Yes, my lord.
Which
There
is
is some
correct.
wrong calculation, my lord. So in this respect, I file additional affidavit as per the honorable court's order, my lord. Honorable court's order dated 27/2/2025. May kindly be seen, my lord.
Where is the additional affidavit?
Additional affidavit I filed, my lord.
When?
I filed it on 5/3/2025.
It is not available on the record.
This is. It is.
There is one office note which indicates that no affidavit has been filed.
No, my lord, I filed it long back, my lord. The date is there.
Maybe office note dated 30/4/2025.
Ready? You need to file for it.
So if the affidavit is not available on the record, I will not pass any order on the basis of this document filed by you.
Of course, this is correct, my lord, but the fact remains, my lord, I have filed it properly. Though,
Condonation of delay. Delay of put in bracket later. As stated in the paragraph number 3 and 6 for 254 days, and as stated in the paragraph number 7 is for 314 days. Mr. Mazhar Bhaiya, learned counsel for the applicant submits that pursuant to order of this court dated 27/2/2025, he has already filed an additional affidavit correcting the exact number of days to be condemned. But the said affidavit is not placed on record. Accordingly, it is provided that recessal lays the matter and closing the affidavit filed by the applicant on next day. List after 1 week.
Online. Very favorable.
Item 25.
May I please, Your Lordship? Lordship, as per office note dated 19/5, Your Lordship, service upon respondent number, except 9, Your Lordship, service are complete, Your Lordship.
Respondent number?
Except 9, Your Lordship. And Lordship, respondent number 1 and 2 expired, Your Lordship. They belong from same family, Your Lordship. Lordship, may payers order dated, office note dated 19/5, Your Lordship.
So you have to take a step upon them for implement of the legal heirs.
They are from the same family, Your Lordship. Respondent number 1 is the
not necessary.
Not necessary, Your Lordship. And all these respondents are from the same family, Your Lordship.
Okay.
9 is the performer respondent, Your Lordship.
So you want to take fresh step upon respondent number 9?
Lordship.
Heard, Mr.
R. Boro, Lordship.
Or Borua?
Boro, Lordship.
Boro.
Lordship.
Learned counsel for the applicant, struck appellant. Office note dated 19/5/2025 indicates that service upon respondent number 2, 4, 5, 6, 7, 8, and 10 completed. The said office note also indicates that respondent number 1 and 3 suffered demise. Mr. Boro, learned counsel for the applicant, appellant, submits that as respondent number 1 and 2 belongs to 1 and 3 belongs to the same family. And they're adequately represented by the respondent. There is no requirement for implement of their legal heirs. The office note dated 19/5/2025 also indicates that service report in respect of the performer respondent number 9 is still awaited. Accordingly, it is provided that Mr. Boro, learned counsel for the applicant, struck appellant, shall take fresh step upon respondent number 9 by registered post with AD and also by usual process within a week from today. Please the matter after.
Here, Lordship, after filing of this petition, Your Lordship, we come to know that title execution has been filed in court below, Your Lordship. So
you file one IA for
Lordship,
saying that
Lordship.
execution. We'll see that.
Apply the law.
26.
Wait, please, your lordship. As per office note dated 17/5/2025, service is complete upon respondent number 2. And respondent number 1 is representing, your lordship.
This I is for condonation of delay.
Yes, your lordship. There is a delay of 66
Yes,
days.
Talukdar, any,
I am not having the copy of the delay continuation petition.
pardon?
I am not having the copy of the delay continuation petition.
Furnition copy.
Okay,
to-
your lordship.
Any objection in condonation?
Very condoned.
Condon. Okay. Heard Mr. S. Dr. Learned Counsel for the applicant. Then also heard Mr. Talukdar for respondent number 1. Office note dated 17/5/2025 indicates that service upon respondent number 2 completed. But respondent number 2 remain unrepresented today. This interlocutory application is preferred for condonation of delay of 66 days in filing connected appeal against the judgment and order dated 3rd of February 2024, passed by the learned member MSCT. Nagaon in MSC case number 20 of 2021. Mr. Dr. Learned Counsel for the applicant submits that the appeal could not be filed in time due to. What is the reason?
Your lordship, procedural delay.
In
or
which
trans-
paragraph of the application you have
Paragraph 5.
explained it?
5, your lordship.
Paragraph number?
5.
Sir, Dr. Learned Counsel for the applicant submits that the appeal could not be filed in time. Yes, there was delay in obtaining approval from the regional office. And also in getting the certified copy of the judgment and award dated 16 to 2024. And the delay is not intentional, rather it is circumstantial and therefore it is contended to condone the same. Mr. Talukdar, Learned Counsel for the respondent number 1 submits that he has no objection in the event of condoning delay of 66 days in admitting the appeal. In filing the appeal. But having heard the submission of Learned Counsel for both the parties, I have carefully gone to the petition and the documents placed on record. And also the grounds mentioned in paragraph number 5 of the application. Taking note of the submission of Learned Counsel for both the parties and also taking note of the grounds mentioned in paragraph number 5. This court is of the view that the delay of 66 days in filing the connected appeal is sufficiently explained, and therefore the delay of 66 days in filing the appeal stands condoned. In terms of this IA stands disposed of. In view of the order passed in IA, the registrar shall now register the appeal and list the same as soon as practical.
Lordship, my prayer is that my name may be reflected in the appeal. My name may be reflected in the appeal.
Okay. Mr. Talukdar submits that his name is not reflected in the cause list, and as such,
No,
the
Lordship.
may be registered to reflect
In
his
the
name.
cause list it is reflected, but in the appeal,
My name may be David.
Appeal. Okay, appeal.
27.
Much of Lordship, copy of the memo will maybe comes.
Okay.
27.
In this case, respondent 1 to 5 has appeared.
1 to 5.
So let's number 1 to 5, Lordship.
Okay. How many respondents are there?
7 respondents.
Oh,
Yes.
other two?
Owner and driver.
Regarding 6 and 7, service is not completed, let's say.
6 and 7.
Delay of 65 days.
Pardon?
In this case, the delay of 65 days in filing the appeal.
But the notice has to be served upon 6 and 7.
Service may be awaited for regarding the respondent number 6 and 7.
Heard Mr. K.K. Bhatt, learned counsel for the applicant and Madam
S.E. Ahmed.
NC
S.E. Ahmed.
SD Ahmed, learned counsel for respondent number 1 to 5. Office note dated 1/5/2025 indicates that neither ready card nor unsserved notice in respect of respondent number 6 and 7 received by the section. Recessal is the matter after 2 weeks, awaiting service report upon respondent number 6 and 7.
28.
Lordship may take up Miss Case 67, 2024. First year, Lordship. This is a petition for restoration, Your Lordship. The CRP was dismissed for default. Otherwise, a landlord-tenant matter. It was previously it was being the CRP was filed by Mr. B.R. the senior advocate and his chamber advocates, Your Lordship. Mr. B.R. they passed away, and one of his junior also passed away. Thereafter, the brief was handed to Mr. S.S. Sharma. For some reason, maybe the Wakalatnama did not get tagged and the matter was unrepresented when the matter was taken up on 10/4/2023 and the matter was dismissed for default. I am only praying that it may be restored on next date. We can go for the final hearing on merits, Your Lordship. That is the limited prayer.
My lord, I am appearing on behalf of the respondent. The revision was not dismissed for default. That was dismissed for not taking steps about for 7 years. And for non-prosecution, your lordship may kindly come at page 18 of their application, Your Honor. I am reading, Your Honor. Order was passed on 10/4/2023.
Page number?
Page number 18, my lord.
18.
Yes, my lord. The
Yes.
present revision petition is directed against a decree of rejectment dated 9/5/2011, passed by the landed Munshi Bogaigaon, and order dated 1/7/2014, passed by the landed civil judge Bogaigaon, upholding the order of the landed Munshi Bogaigaon. The matter was admitted for hearing on 5/11/2014, my lord. Thereafter, when the matter was listed on 31/2015, this court directed the landed council to take rectificatory steps on 2/2/2015 in terms of office note dated 28/1/2015. No such rectification has been done till date. The office note dated 28/1/2015 reflects that notice to the respondent number 1 could not be issued due to deficit postal staff. Thereafter, the Lojima Court, under its order dated 27/5/2016, directed the petitioner to take steps for issuance of notice upon respondent number 2, 3, 4, 5, and 6. However, till date, such steps has also not been taken. None appears for the petitioner when the matter was called. Accordingly, the present revision petition stay dismissed for non-prosecution and for want of steps. Interim order so vacated. So that was the case, my lord. Now they have come stating that that was dismissed for default. That was not dismissed for default. And their petition, they have filed the petition under Order 9, Rule 9. Their application is also not maintainable under the law because under Order 9, Rule 9 relates to the suit. If the suit of the plaintiff dismissed, then he can file the application for restoration of suit. they have come under order 9 rule 9, that is also not applicable. Proper application has not been filed. Moreover, my lord, before that, they have also filed an application, this case, that was the 38 of 2024. That for a readmission of the appeal, that was withdrawn by them with the permission of the court. Thereafter, they have filed this application. Now the suit is filed by me in the year 2006. Now 2025 is running, my lord. I am suffering, my lord. They are not taking any interest. So many opportunity was given to them for taking a step. They have not taken the steps, my lord. And another thing, my lord, if it seems that it is also barred by time, they are taking plea that earlier senior advocate had expired, but junior was there. And the another advocate, Mr. S.S. Sharma, was engaged after dismissal of this case on 23/5/2024. So there is nothing mentioned in the petition how they have come to know about this dismissal of this revision petition. Means they are they have some sources. They are watching the case. Otherwise, how they have come? Because by that time I have not filed any education case. Immediately after dismissal, after 15 or after more than 1 month, they have filed that first restoration application that was withdrawn by them. Now again with this matter. So that this application filed by them is not maintainable under the law. They should have filed application for review of the order. That is the better manner. That was the proper procedure. Then court can review because it is dismissed for not taking steps. About my lord for 7 years, my lord. I am the landlord, my lord. I am suffering. I think the case since 2006, my lord. I should have decreed on default and bona fide requirement. Even, my lord, they are not paying the rent to me also. I have enclosed the copy of the NJ case. They have paid the rent only month of December 2023. Thereafter, they are not paying, even not depositing the rent in court. Nothing, my lord. Enjoying the suit property, my lord. So my submission, my lord, this application is
So,
liable to be dismissed.
Mr. Mukherjee,
Yes.
regarding this CRP was dismissed not for default, but for
Non-taking of
prosecution
steps.
for want of step.
For want of steps also amounts to default on the part of the petitioner. And my submission here, your lordship, my instruction is that the parties against whom steps were not taken, their name may be struck off because they are not necessary parties as on date, your lordship. They are my relatives who are not having possession over the property. Only the petitioner herein is the tenant, he is having the possession, and they may be deleted at my own risk and cost. And the landlord is here, your lordship. So if it is taken up for hearing in presence of the landlord and the tenant on merits, your lordship, the other parties will not be prejudiced. Their name may be struck. At my understanding, at my instructions, your lordship.
My lord, they have made the parties.
Because-
Profound dependent,
because-
they have not taken steps. Even this revision petition is not restored. So my learned friend cannot make the submissions regarding
They were made-
striking of the name of other respondent.
They
He
were
cannot
made
make.
pro forma
When-
parties.
So if he wanted, he could have done at that time also, but he did not. Sole intention was to delay the disposal of this. Now with that view, now again he making a submission by law before this one will go out. So first my submission, this petition is not maintainable under order 9 rule 9. How they have come under order 9 rule 9? Your lordship knows, your honor, and I am reading the provision of order 9 rule 9, my lord. What order 9 rule 9 say, my lord?
No, merely because misquoting or wrong quoting of a section, we cannot dismiss the petition.
That is there, my lord. That can be done, but they are filed. So recourse is to file a review petition. That was there because that was dismissed for not taking steps. If that
No,
would
the
have been
question
for
is whether it is the same thing that dismiss for default and dismiss for not taking step.
not my not same, my lord.
Not same.
Dismiss, not same, my lord. Not same, my lord. That was not dismissed for default. That was clear order of this honorable court that was dismissed for want of steps or for non-prosecution. So that matter is different. This matter is different. So how the court can review? It's on order on the basis of this application filed before this honorable court. if they would have come for review, this honorable court could have considered it, or your lordships.
Yes, Mr. Mukherjee, you file appropriate petition.
Lordship, my submission regarding making them parties, your lordship. Those pro forma parties.
No, regarding maintainability of the petition.
Order 9, Rule 9. Because here, your lordship, Order 9, there is no specific provision as to restoration of a CRP. Revision is an offshoot of a suit itself, your lordship. So there is no provision in the CPC which says what happens when a revision petition is dismissed. And even the submission, your lordship, that non-taking of steps also amounts to dismiss for default. Order 9 rule perhaps 5 will clarify that if steps are not taken, the suit is also liable to be dismissed.
Order 9,
Rule, I am
rule.
4 and 5. Rule. Rule 8 is clear. When the plaintiff is not present, your lordship, then where the defendant appears and the plaintiff does not appear, when the suit is called for hearing, the court shall make an order that suit be dismissed unless the defendant admits the claim or part thereof. So they were not present admittedly in this case here also. Your
That is related to the plaintiff.
And
if
order-
I filed the suit, I did not take steps, then the court can dismiss the suit for not taking steps. Here suit is not dismissed. Suit was decreed. They have challenged the impugn order. So proper recourse for them was under order 47 rule 1. And under 47 rule 1, it was especially stated regarding revision also. My learned person submitted that there is no provision under the CPC, but there is a provision, my lord, and I am reading, my lord.
Order 47.
Yes, my lord. Order 47, rule 1, my lord. Application for review of the judgment. Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been prepared, by a decree order from which no appeal is allowed, or by a decision or reference from a court so and so, and who from the discovery of new and important matters, evidence, which after the exercise of due diligence was not within his knowledge, could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason, that shall be covered, for any other sufficient reason, desired to obtain a review of the decree passed or order made against him, may apply for a review of judgment to the court which passed the decree or made the order. So that was the order that they could have filed for any sufficient reason. So that was the proper recourse. This would have come under order 47.
In my humble understanding, your lordship, had the case been decided on merit and had I been praying for review, then order 47 would have been invoked, your lordship.
Order, what is order? Judgment or order, that is the order.
But the suit was never decided on merit. It was decided because the petitioner who had filed the suit was not present, and on the previous date, there were some orders as to take steps, and steps were not taken as such.
So that was not, so judgment was not passed. Because a case was not decided on merit, so judgment was not passed. Order was passed for not taking a step. That too for 7 years, my lord. For 7 years, my lord. So proper application should have been under 47, and the court could have considered. Because what is used for sufficient reasons, other sufficient reasons.
So you file proper application.
I may find some judgments where if to show
Okay, then
that
I will fix the matter for hearing on the point of maintainability.
whether restoration application is applicable to revision petitions as well or not. That much I can try to find some judgments if possible.
Heard Mr. Mukherjee, learned counsel for the applicant, and also heard Mr. R.C. Samseti, learned counsel for the respondent. Place the matter after a week for hearing on the point of maintainability of this petition.
Good
night.
May please, sir. Kindly, madam, maybe pass for the day. My senior is also the session as the Borwa. At Arunachal Pradesh.
Any objection?
No, Lordship. I am for respondent number 1.
What? Heard, Mr.
As new.
Yes?
New.
Now, learned counsel for the applicant and Miss
C. Agarwal.
C.
Agarwal.
Learned counsel for the respondent number 1. Mr. Nev submits that conducting counsel Miss S.G. Borwa is out of station.
Yes, sir.
Out of station. And as such, he applies for adjournment of the matter for the day. Fair allowed. Recess the matter after a week.
Monday
Next Monday.
Much obliged.
Okay.
That is the lordship. Lordship, it is an RSA. The record has already been received and matter is ready for hearing. So far the miss case is here, lordship is concerned. So in the miss case, I filed an application being an appellant for an injunction. Order 39 rule 1 and 2. Expecting
Mr.
lordship.
Yeah,
Lordship.
this appeal was filed in the year 2020.
Lordship. In 28. Lordship. As of 2020.
So what is the necessity of granting injunction at this stage now?
Lordship, what
You
happened?
can finally hear and dispose of the matter.
Lordship, that is why I am submitting. Lordship, finally disposed of. It is simple matter. Lord, I have filed this appeal against the order of remand passed by the appellate court. So that matter can be disposed of.
Only problem might have page 104 may be seen for it. The first appellant court might not dismiss the appeal but remand it. That is the problem.
That is the problem. Dismiss my appeal and remand the matter for prior disposal, and another issue has been decided again. So that is a matter very simple, lordship, that is to be decided and appeal to be set. The decree passed by the appellate court is to be set aside. And on being remand, I have no objection. But findings given by the trial appellate court, setting aside the judgment of the trial court.
Where is the judgment?
Lordship.
104 please translation order.
Lordship, this
problem.
the appellate court judgment, lordship. Page 81.
Okay, you would suggested that then
Suggested date. Lordship, in the month of June, lordship. June.
heard Mr. R.K. Punya, learned counsel for the appellant. And also heard Mr. Hawk, learned counsel for the respondent.
1 to 10.
1 to 10. Mr. Punya submits that the matter is ready for hearing. Then accordingly, it is provided that recess and list the matter for hearing on
26 June.
Sorry.
26. Date of hearing, not 19 June. Lordship.
Okay.
41.
May it please your lordship. Well, this is regarding substitution of respondent number 5. Respondent number 5. And the petition is for condonation of delay 197 days. And a 2-day notice has to go.
Pardon?
2-day notice has to go on condonation petition. Miss case 49.
492.
Yes, ma'am.
But the counsel for respondent appears.
I am for the respondent number, lordship, 1, 3, and 4. 4 also died meanwhile.
1, 3, and 4.
Yes, lordship.
My lord, we have filed an application for substitution that has not come with the record.
And so far this respondent is concerned, Lordship, 8 years have elapsed. Though the tenant, the present appellant before your Lordship, resides in the same compound. It is not a fact that they had no knowledge about the death of their landlord. This is one thing. More particularly, Lordship, one more thing I would like to submit, that respondent number 5 perhaps had not appeared in the appeal itself so far. Anyway, his legal heirs are to be substituted, but it stands abated as against him.
Respondent number 4.
Respondent number
5.
4, 5, both, Lordship.
4, 5, 4.
Both, Lordship. 8 years delay so far.
Then
Respondent
in,
number 5 is concerned.
you were not appearing for respondent number 2.
I am not appearing, Lordship. 2 is still to be
So
served.
notice has to go to respondent number 2.
Notice is to go to respondent number 2 also, if not served, Lordship. This is one thing. But so far, 4,
Prior to that, they have to substitute.
yes, 4, 5 are concerned. Both are actually, both have passed away. And
So you file appropriate petition then.
My lord, this application, this Miss IA 492 is for condonation of delay for substitution of heirs of respondent number 5. Notice is to
Then
go on.
4.
My lord, we have filed the application has not annexed with the record.
Okay.
It is, my lord.
Okay. Third, Mr. J, learned counsel for the applicant, then Mr. Talukdar, learned counsel for the respondent number 1, 3, and 4. Mr. Talukdar submits that respondent number 4 already suffered demise and 5 also suffered demise. And the applicant has to take step for substitution of legal heirs of respondent number 4.
5.
4 and 5. Then the present application is preferred for condonation of delay of 197 days in filing an application for application under order 22 rule 2 of the Code of Civil Procedure for substitution of legal heirs of respondent number 5. Respondent number 5.
in both cases, abatement, are Lordship.
So let a notice be issued to the respondent number 2. Returnable in 4 weeks. 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
Obliged, Lordship. 32.
May it please your lordship, the opposite party has appeared, NCR has also been received, maybe fixed for hearing.
Hearing. Heard, Mr.
C. Gogoi, your lordship.
C. Gogoi, learned for the
Appellant.
this IA is for what purpose?
IA was for stay. Stay was granted on 2/4/25.
Stay granted.
Stay was granted by this honorable court on 2/4/25.
Till disposal of the appeal or stay was granted till disposal
Till
of the
returnable date, your lordship. Till returnable date.
returnable.
Since a limited issue is involved, my lord, can an early date for hearing be fixed?
Sure. 25 method. LCR has not been received.
My apologies, I inquired, there was must have been some misunderstanding, I apologize.
In the course, this minority soon, let's see.
But there is an office note in the appeal.
I apologize.
Heard Mr. C. Gogoi, learned counsel for the appellant, and also heard Mr. S. Das, learned counsel for respondent. Office note dated 6/5/2025 indicates that the LCR has not yet been received. It is provided that raises also reminder to the learned courts below for transmitting the record without further delay. List the matter after 2 weeks. After 2 weeks. And in IA, you take down hard so and so so and so. Interim order passed earlier, since extended till next day. This after 2 weeks.
Yeah, please, Lordship. Lordship, as per the direction of this honorable court white order dated 10/3/2025, we have taken steps for substituting the legal errors of respondent number 2. 2 IAs were filed.
Lordship, I am appearing on behalf of respondent number 2. We have instruction to appear in this matter.
Respondent number
2. Some new substituted respondent. Lordship.
how many respondents are here?
Three.
So others are related. You can appear.
Yes, Lordship. We also appear 1 and 3, Lordship, and now we have instruction to appear on behalf of respondent number 2, Lordship.
Legal errors.
Oh, all the respondents. One.
What are legal errors?
Third, Mr.
W. Hawk, on behalf of
W?
Mr. W. Hawk,
W. Hawk, learned
On behalf of
counsel,
Mr. A.
appearing on
Sattar.
behalf of Mr.
A. Sattar,
S.
A. Sattar,
A. Sattar, learned counsel for the applicant, and Miss
AB Kayastha.
A.B.
Kayastha.
Firestone, learned counsel for the all the respondents. You file your Wakalatnama?
Lordship, 1 and 3, I have filed, but 2 we have Wakalatnama is
Ms.
filed.
Firestone submits he has already filed a power in respect to respondent number 1 and 3, and will be filing the power in respect to respondent number 2 within
1 week, Lordship.
1 week from today. This application under order 22/4 of CPC is preferred by the applicant for substitution of legal heirs of respondent number 2. Namely, Sri Bakul Kumar Gogoi, who suffered demise on 25/10/2022. So you want to file objection here?
No, Lordship, we have no objection.
No objection.
No objection.
But the problem is that unless you file Wakalatnama for the other respondent, we cannot dispose of this petition.
Lordship, then fix it after 1 week, Lordship. In the meantime, I have filed a Wakalatnama.
Proceduralize the matter after 1 week. After 1 week. Immediately after filing of Wakalatnama in respect of respondent number 2 by Ms. Kayastha, learned counsel for the respondent.
Deeply observed.
Item 35.
May I please, Your Lordship?
Thank you, Lordship. Lordship, by filing this application, I'm paying for direction to the insurance company to deposit 50% of the ordered amount and to release the same. Although appeal was admitted, but no order has been passed for release of any amount. Yeah, the
No,
payment.
whether any stay was granted.
No, the stay
was
was,
not granted.
prayer was there,
Prayer was-
but they have not received.
Lordship, but I have filed an objection against his petition for deposit of 50% of the awarded amount. That is, I think, on.
Why? Why?
Lordship, there are certain grounds we have taken, Lordship, which were not considered at the trial.
No, that will be
Lordship.
considered at the time of hearing the appeal.
Lordship.
Since
But
the appeal has
Lordship,
been admitted, you
already
get
appeal has
50%
been
amount.
admitted, also LCR has been called for. Appeal has been already been admitted and
Yes.
LCR has been called for also. And LCR will reveal certain facts, Lordship, and we have disputed the DL of the driver, which was not considered, Lordship, and the disability certificate, Lordship. Again, the disability percentage, which is 40%, was taken to 50%, Lordship, without any valid grounds. So these are some out there. There was another grounded, there was a head-on collision, Lordship, and the claimant has already admitted, respondent number 1 admitted during his court examination, Lordship. That part was also not considered in the impugned judgment, Lordship. These are the grounds which we have taken.
No, that,
So as this case,
those
Lordship-
grounds will be considered at the time of final hearing of the appeal.
Yes, I understand, Lordship. Another vehicle is also there. They haven't appeared, Lordship.
What is the amount?
It's 16, that's 24,359 at a rate of 9% interest. But they will not prejudice if the appeal is disposed of finally,
Best,
Lordship.
the amount
They
will
will
be
get the interest
decreased,
amount.
Lordship. At least 50% may be released, Lordship. And the ground taken is not sustainable, Lordship. There is,
Okay, that will be
maybe there
decided
is
on
void
maybe
on
at
condition,
the time of
but
hearing.
charge sheet is against the
Okay.
driver of the offending vehicle.
Okay.
Disability case, Lordship, 40% disability, Lordship.
Pardon?
Disability case, Lordship, 40% disability. Accident occurred in the year 2017. Till that, we have not received any amount, Lordship. 4%.
Lordship, on that regard, we have already disputed the disability certificate. The doctor who issued the disability certificate is not examined, and there is a decision of this bench of this High Court, Lordship. It is required to be examined, the doctor who issued the certificate, Lordship. Here in this case, he was not examined and he was hospitalized for only 5 days, Lordship. In that regard, Lordship, and the claim petition also doesn't disclose anything that he has suffered such fracture injuries, whether he was operated, Lordship. This will clearly establish after receiving of the LCR only.
So the 2 orthopedic surgeon was examined, Lordship.
But they did not issue the disability.
And disability has been duly.
Okay, we will say, but only then we will hear your appeal.
Lordship, at least 50%, at least
50% of the amount
Lordship.
before this court. Pardon, sir.
And
Pardon,
the
sir,
Lordship.
for the applicant and also heard Mr. PJ Burman, learned Sunday counsel for respondent number.
I am number in the IA, Lordship, I am 1.
Respondent number 1.
I am the insurance, Lordship. I hate you. That's one question.
United India Insurance Company Limited. By judgment and award dated 16th of November 2024, the learned member, Motor Accident Claim Tribunal, Certificate MSCT Kasar, Silsor, has directed the respondent number 1 herein this petition to pay a sum of rupees 16 lakhs 24,359, being the compensation to the applicant herein with interest at the rate of 9% per annum from the date of filing of the claim petition. That is 24/5/2018 till payment is made. Being aggrieved by the aforesaid judgment and award dated so and so, the respondent herein filed an appeal being MSC appeal number 46 of 2025, which has already been admitted by order dated 24/2/2025. and LCR has already been called for. And along with the aforesaid MSC appeal number so and so, one application for staying
I haven't filed a separate stay.
15 page 15 Lordship, in the memo of appeal. In the memo of appeal
The memo
itself,
memo
they
of-
pray for
separate IA has
stay,
not been filed.
not filed. In the memo of appeal,
In
page
the
number
mem-
15
uh,
Lordship.
You delete that line. And though no separate interrogatory application is filed for staying operation of the impugned judgment and award, yet a PR was made in the memo of appeal itself for staying operation of the impugned judgment and award. But the same has not been pressed before this court at the time of admitting the appeal. And as such, there is no stay of the judgment and award. So passed by the learned member motor accident claim tribunal plus are still short of the judgment and award dated 16/11/2024. This present interlocutory application is preferred by the applicant for issuing direction to the respondent number 1, the insurance company, to pay 50% of the awarded amount. Pursuant to the judgment and order dated 16/11/2024 in MSC case number 135 of 2018. Mr. Talukdar, learned counsel for the applicant, submits that the applicant is the victim. Is the claimant in the MSC appeal number, no, in the MSC case number
135 of
135 of 2018, and he suffered disability, 40% disability in the accident, and he has been suffering from acute financial crisis. And as such, there is a requirement for directing the respondent opposite party to deposit 50% of the awarded amount before the registry of this court. Mr. P.J. Borman, learned counsel for the respondent, submits that he has filed an objection in allowing this application, as there are several grounds which were taken before the learned tribunal, but not considered, but the same were not considered by the learned tribunal, and the LCR will reveal the aforesaid grounds. And on such count, Mr. Bormon submits that this petition may be dismissed. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record. And also, there is the impugned judgment and order dated 16/11/2014 in MSC appeal number 135 of 2018.
MSC case number, Lordship.
MSC case number so and so. And also the order passed by this court dated 24/2/2025 in MSC appeal number 46 of 2025. It appears that in the impugned judgment and award dated 16/11/2024, the learned tribunal has directed the respondent opposite party herein to pay a sum of rupees 16,24,359 rupees with interest at the rate of 9% from the date of filing of the application, claim petition. Taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to allow this petition, allow this application. the respondent opposite party number one is directed to deposit 50% of the awarded amount before the
40%.
receipt of this court.
Yes, for 40% also. Sorry. Lordship, then, and, then
50%.
bond shall be executed by the.
And
Within a period of 4 weeks from today.
and the action may be we have to release the said amount.
And
Subject to a bond launch.
and the applicant may be allowed to withdraw the same on furnishing a bond.
And judgment may be state lordship.
Pardon?
Judgment may be state.
No. This application is for granting 50% of the amount. This is not a pair for state.
Yes, lordship. Okay, so on next date.
37? 36.
I'll share to 100.
36.
Item 36 is delay condonation petition is there. Notice will go.
We'll call it. Please sit down. Please sit down.
37. My lord. This is for clarification of the order, my lord, had passed on 28/4/2025, my lord. My lord, page 15. Page 15, paragraph number 14, my lord. The respondent authorities are directed to consider the case of the petitioner for being appointed as part-time guest faculty in any of the polytechnics of Assam. That is absolutely fine, my lord, but I was aggrieved by my expulsion from the list of 3F appointees, which is reflected in paragraph number 2 at page 9. Paragraph 2 and 3. These are the facts, my lord. So if it could be clarified that pursuant to the notification.
Paragraph number?
Paragraph number 2, my lord, at page 9. The petitioner as lecturer in any polytechnic in the state of Assam under regulation 3F APSC regulations 1951 and to direct the respondent authorities to allow the petitioner to render his service at Baksa Polytechnic College, Baksa. My lord, thereafter your lordship will kindly come to page 10. Page 10, my lord, the last paragraph. I was a part-time faculty. Thereafter, by notification dated 22/1/2025, 100 numbers of part-time guest faculties were absorbed under regulation 3F and were posted at various new places of posting, but the name of the petitioner did not figure in the aforementioned list, even once so-and-so. That 3F list, my lord, I need to be inducted into the 3F list that I was not included in. That is my case, my lord. That was my case. And subject to your lordship's majesty, paragraph 14 might not indicate the true purport of your lordship's relief that I was granted.
So we have to add a regulation 3F here.
Only 3F, and the list where regulation 3F pursuant to the notification dated 22/1/2025. That was all. Because what had happened, my lord?
So here only we have to incorporate under regulation 3F.
Regulation 3F as was done with similarly situated part-time lecturers by notification dated 22/1. That is my case. Because what had happened, my lord, is that I was yes. But your lordship is correct. Only 3F. As with similarly situated.
Yes, anybody for respondents?
I'm for the AICT, my lord.
What?
AICT.
We
have nothing to say, my lord.
Any objection?
Lordship, we have sent this file for instruction is yet to arrive. We were waiting for the instructions.
What argument koi la rahe tum?
No, here only we have to add one word under regulation 3F.
Yes, that's all.
So what instruction is required?
Not UGC. My credentials were verified pursuant to the submission of the UGC and the AICT. But the issue here is primarily between the petitioner and the state department. That is all. what had happened, my lord, just in 2 lines, I'll submit, my lord, that there was a cabinet decision of 24/9/2024, which talked about.
No,
absorb-
no,
yes.
wait, Mr. Soma.
Yes, yes.
Yes. So what instruction is necessary here? We add the word under regulation 3F of the APSC. Any instruction is required?
Your Lordship, I'm not aware of it. I'm not sure.
You are not aware of. Copy of the application is not available with you.
Yes, it's there with
Available.
us. It's there with us.
Then. Mr. Soma, let it be on Friday. In the meantime,
Yes, no.
let him obtain instruction.
No, because
Heard.
yes, yes.
Heard, Mr. Sharma. Learned M. Sharma, learned counsel for the applicant. Then Mr.
YN Mohanto.
Y. Mohanto, learned
Three,
counsel for respondent number.
3.
Respondent number 3 and Mr. B does learned counsel for AICT. Respondent number 4. This interlocutory application is preferred by the applicant. Oh. Clarifying the judgment and order dated 28/4/2025 passed by this court.
Yes, ma'am.
The learned counsel for respondent number
3.
Respondent number 3 submits that he has not received any instruction. And in view of the submission made by him, it is provided that recessal is the matter on Friday. So as to enable Mr. Monto to obtain necessary instruction.
36.
May it please your lordship. The
Yeah.
second appeal was dismissed for default for not showing the name of the council in the causal list. And we filed an case for readmission of the appeal. And there is a delay in filing that readmission of appeal applications. That IA 1499/25. Today for the first time it has come. So notice may go to the other side. The delay condonation petition.
Heard, Mr.
J. Decker.
Say they can learned counsel for the applicant. This interlocutory application is preferred by the applicant for condemnation of delay of 349 days in filing application under order 41 rule 19 of the Code of Civil Procedure for readmission of RSA number 14 of 2010, which was dismissed for default by order dated 12/3/2024. Where is the application? Let notice be issued to the respondents. Returnable in 4 weeks, the bid taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
38.
Obliged.
Lordship, the cases for issue of the condemnation of the delay of the petition, issue notice may be given.
Heard, Miss?
S. Agarwal.
Yes, Agarwal, learned counsel for the applicant. This application under section 5 of the Limitation Act is prepared by the applicant for condemnation of delay of 2,275 days in filing petition for substitution for restoration of CRP number 261 of 2016. Where is the application of the documents placed on the record? Notice to issue to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Please the matter after 4 weeks.
Obliged.
43, partner.
May it please, yes, madam. Malad, here is a case, Malad, where the present petitioner number 2 is a bank, private sector bank, Malad. And on a complaint being filed by the respondent number 2, an inquiry committee was set up under the Prevention of Sexual Harassment Act.
Other side?
Other side was here, Malad. No, but
Well, I resume at 2 o'clock.
2 o'clock. Maybe they thought it's still 1 o'clock. That's somebody.
Pardon?
It's still 1 o'clock, so maybe they left.
Yes, maybe.
Maybe because.
The matter may come up on Friday, my lord, with the consent of other side, my lord.
Lordship has heard it otherwise, Lordship, and so my friend was required to place a judgment in this matter.
I have got
If
those
possible on
judgments.
Friday, Lordship.
On Friday,
Yes,
it will be
Lordship,
better
difficulty.
for both of us.
Friday already, we have several matters.
It won't take much time, my lord, 10-15 minutes. Thanks,
Okay,
sir.
as agreed by learned advocates of both the parties, recessal is the matter, right?
Most of them.
Obliged, Lordship.
44.
May please, your lordship. Lordship, I have taken justly upon the respondent, my lord. The respondent have appeared today, lordship. So let the matter be fixed for admission, my lord.
What?
Admission.
Admission. Heard Mr. Edeka, learned counsel for the petitioner, and Mr.
G. Bharadwaj.
G. Vardas, learned counsel.
Interim order, my lord.
Respondents.
Interim order was there, my lord.
Okay. It is submitted at the bar that service has already been completed. And the matter is ready for admission hearing. Accordingly, it is provided that recessal is the matter for admission hearing. After a week.
2 weeks.
After 2 weeks, interim order pass earlier shall continue.
And part matter.
May it please, Ismail. Here is a matter, my lord, where the petition number 2 is a private sector bank, my lord. Having pan-India service, my lord, more than 1,300 branches all over India and more than 3,000 ATMs running all over India, my lord. The petition number 1 is the internal committee formed under section 4 of the Prevention of Sexual Harassment Act 2013. In short, my lord, POS Act 2013, my lord. If the petition number 1 was formed, internal committee was formed on the basis of a complaint that was lodged by the respondent number 2 against the respondent number 1. The respondent number 1 at that point of time was working as the regional segment head of the petitioner number 2 company. So after the inquiry committee was formed under section 4 of the POS Act 2013, my lord, inquiry was done, and on the basis of the inquiry evidence and on the basis of the materials available on record, my lord, the respondent number 1 was found guilty and he was asked to, and he was found guilty, my lord. So thereafter, my lord, what has happened is that against that order, challenging that order, they preferred an appeal, the respondent number 1, before the industrial tribunal. We appeared in the appeal and we filed a written statement, specifically, my lord, stating that the industrial tribunal has no jurisdiction to try the appeal. My lord, and with regard to that, we also filed an application under order 14 of the CPC for framing preliminary issue. That, my lord, will find at page number 4 or page number 98 and annexure 4. Although, my lord, there were 5 preliminary issues that we suggested, but the main issue was issue number 4. That, my lord, will find at page number 104. 104, the last one, my lord, whether the instant appeal is expressly barred under section 4 of the Industrial Disputes Banking and Insurance Companies Act 1949. Page 104. The last one. That was the significant issue, my lord. Thereafter, the respondent number 1, they filed their complaint, they filed their written objection, and after hearing the parties, the impugn order, that is 31/2025, was passed. That, my lord, will find at page number 123, annexure 6. May I read the order, my lord? Both the parties are duly represented by their learned counsel. Case was fixed today for passing an order on petition number so and so, second para, my lord, and the Industrial Disputes Banking and Insurance Companies Act 1949, the dispute in banking and insurance companies are a matter of adjudication by the central government. The section 4 of the Act 1949 clearly states that notwithstanding anything contained in any other law, it shall be competent for a state government or any officer or authority subordinate to such government to refer an industrial dispute concerning any banking or insurance company or any matter relating to such dispute to any tribunal or other authority for adjudication, inquiry, or settlement. Since there is a specific legislation which identifies central government as the appropriate government, the instant appeal cannot be preferred before the present tribunal being void ab initio for lack of jurisdiction. It is also stated that the Prevention of Sexual Harassment Act 2013 is a special legislation in terms of Section 18 of the POSH Act. An aggrieved person has the right to appeal to a court or tribunal in accordance with the provisions of the service of rules applicable to the institution. If the service rules do not exist, then without prejudice to the provisions contained in any other law for the time being in force, the person aggrieved may prefer an appeal to the appellate authority notified under Clause A of Section 2 of the Industrial Employment Standing Orders Act 1946 is applicable to the industrial establishments employing workmen, and the present appellant is neither a workman nor the definition nor the same is applicable to the respondent. On the other hand, the appellant has filed objection on the petition dated so-and-so under so-and-so. Next para, my lord. The provisions of Section 18 of the POS Act 2013 read with Rule 11 of the said Act provides that an aggrieved person affected by the recommendation of the internal committee can file an appeal before the court or tribunal. In such a situation, the person aggrieved has the right to appeal against the recommendation of the internal committee before the appellate authority notified under Clause 2A of the Industrial Employment Standing Orders Act 1946 by the appropriate government. And as such, tribunal has the jurisdiction to adjudicate the grievances of the parties under POSH Act. During the instant case, the government of Assam is the appropriate government as per definition of the appropriate government under Section 2B of the POSH Act, and the state tribunal notified by the government of Assam is the appropriate appellate authority for redressal of grievances arising out of the alleged offence under the POSH Act 2013. That being so, the instant appeal has been preferred against the purported recommendation of separation from the service of the respondent number 1 and subsequent illegal termination from the service by the respondent number 2 rightly before this tribunal, which has the absolute jurisdiction to adjudicate the grievance arising out of the POSH Act. As such, the contentions to the effect that since there is specific legislation which identifies central government as the appropriate government are misconceived and incorrect. Provisions of the POSH Act are designed to apply universally to all employees within an organization, including senior management, irrespective of whether they fall under the definition of workmen in the Industrial Dispute Act 1947. The right to approach the ICC and the right to appeal to a court or tribunal against the recommendation of ICC as provided under Section 18 of the POSH Act apply uniformly to all the employees, ensuring equal access to justice and protection under the law. The POSH Act also clarifies that if no specific authority is mentioned in the service rule, the aggrieved party has the right to appeal before the tribunal or court. The service rule code of conduct of the respondent bank does not specify any particular tribunal or court for appeal under the POSH Act. In that situation, the appellant has the right to appeal against the recommendation of the respondent number 1 before the appellate authority notified under Clause 2A of the Industrial Employment Standing Orders Act 1946 by the appropriate government, and as such, the tribunal has the jurisdiction to adjudicate the grievances of the appellant under POSH Act. Further, the ID Act was implemented to provide procedures and machinery to investigate and settle these industrial disputes of the person defined under workman. This, my lord, is not necessary because we are not harping on that also, my lord. My lord, I come to page number 127. That is the relevant portion, the findings of the learned tribunal. Peruse the case, I got third parameter from the top. Peruse the case record, gone through the provisions of law and heard from the learned counsel of both the parties in their respective pleas. It is clear from the records and documents enclosed that the appeal is preferred under Section 81 of the POSH Act by the appellant before this tribunal. It also appears that the place of occurrence, as mentioned in the appeal, is at Yes Bank Limited, Goel Enclave, first floor, Rudraksh Shopping Mall, Bhangaghar, Guwahati 5. The provisions of Section 18 of the POSH Act 2013 read with Rule 11 of the Sexual Harassment of Women at Workplace rules provides that an aggrieved person affected by recommendation of the IC can file an appeal before the court or tribunal. So the person aggrieved has the right to appeal against the recommendation of the internal committee before the appellate authority notified under Clause 2A of the Industrial Employment Standing Orders Act 1946 by the appropriate government. Here, as per definition of appropriate government, definition under Section 2B, it ought to have been 2B, my lord, of the POSH Act, and the state tribunal notified by the government of Assam is the appropriate appellate authority. The provisions of POSH Act are designed to apply universally to all the employees within an organization, including senior management, irrespective of whether they fall under the definition of workmen in the Industrial Dispute Act or not. The right to appeal the ICC and the right to appeal to a court or tribunal against the recommendation of the ICC are there in the POSH Act. The POSH Act also clarifies that if no specific authority is mentioned in the service rule, the aggrieved party may or has the right to appeal before the tribunal or court. The ID Act 1947 was implemented to provide procedures and machinery to investigate and settle industrial disputes of person defined under the Workmen 2S of the Act for providing certain safeguard to the workmen. The Act is not applicable to the person who are not workmen under the Act. Admittedly, the appellant is not falling under the definition of workmen. Section 4 of the Industrial Dispute Banking and Insurance Companies Act 1949 makes it clear that state provisions addresses the referral of industrial disputes concerning banking or insurance companies for adjudication, which falls under the realm of ID Act 1947. The provision of Section 4 is intended to centralize the authority over industrial dispute at the central government level, thereby excluding the state government from referring such dispute. Further, the provisions of CPC 1908 is not applicable while adjudicating appeal preferred under Section 18(1) of the POSH Act and Order 14, Rule 2 of the CPC. The court is only empowered to formulate a single issue to be tried as preliminary issue, but in the instant case, the respondents are trying to formulate as many as 5 issues to be tried as preliminary issues under the relevant provisions of law. Here, quoting the provision of Section 2A of the ID Act 1947, admittedly as erroneous along with Section 81 of the POSH Act in the cause title of the instant appeal does not deter the appellant in getting justice. Moreover, the reliance of provisions 2A, 2S, and 2S3 of the Industrial Dispute 1947, along with provision of Section 4 of the Industrial Dispute Banking Insurance Companies Act 1949, by the respondent cannot take away the jurisdiction of the tribunal over the POSH appeal. So in view of the above, so my petition was rejected, my lord. So against that, my lord, we have preferred this present revision petition.
So what wrong with the order?
On 2 counts, my lord, that the tribunal has vested upon itself, my lord, a jurisdiction which was not vested upon it. Secondly, my lord has come to the last paragraph that CPC is not applicable. Whereas, my lord, a proceeding under the POSH Act, my lord, Section 11, subclause 3 specifically states that the internal committee will act as a civil court, having all the powers of a civil court. I'll just place some my lord, relevant provisions of law that my lord will take up. First, my lord, may come to the Sexual Harassment of Women at Workplace 2013 Act.
Page number? Section?
Section 2B1 may first be taken up, my lord. What is appropriate government? Whether it is the state government or the central government.
Yes.
First page itself, my lord. 2B1, appropriate government means in relation to a workplace which is established, owned, controlled, or wholly or substantially financed by funds provided directly or indirectly. A, by the central government or the union territory administration, then the central government. And B, by the state government, if it is funded wholly or substantially by the state government, then state government. Here, admittedly, my lord, I'm a private sector banking company, and I'm guided by the RBI guidelines and the central rules, my lord. So I do not get any fund from the state government. My funding, my regulations, rules, those are all aligned to, my lord, the RBI guidelines, my lord. Hereafter, my lord, now, how appeal has to be preferred, that is given in Section 18 of the POSH Act, my lord. That has to be read along with Rule 11 of the safe rules, my lord. So what is appropriate government? We have come to know from POSH Act that
which side?
My same act, my lord. I have given another act, just I'll be reading in concurrence. That's it.
Yes.
Section 18, how appeal has to be preferred.
Yes.
Any person aggrieved from the recommendations made under subrule 2 of section 13 or subclause 1, 2 of subsection 3 of section 13 or subsection 1 or subsection 2 of section 14 or section 17 or non-implementation of such recommendation may prefer an appeal to the court or tribunal in accordance with the provisions of the service rules applicable to the said person, or where no service rules exist, then without prejudice to the provisions contained in any other law for the time being in force, the person aggrieved may prefer an appeal in such manner as may be prescribed. So it has to be preferred in 90 days. That is what clause 2 says. This has to be read in connivance with, my lord, the rules, that is rule number 11. Rule number 11 says, my lord, the appeal, how it is to be preferred and under what section. Subject to provisions of section 18, any person aggrieved from the recommendations made under subsection 2 of section 13 or under clauses 1, 2 of subsection 3 of section 13 or subsection 1 or subsection 2 of section 14 and 17 or non-implementation of such recommendation may prefer an appeal to the appellate authority notified under clause A of section 2 of the Industrial Employment Standing Orders Act. So now the most important thing comes, my lord, what is section 2A of the Industrial Employment Standing Orders Act? If I take that act, my lord has the act. I can give a Industrial Employment Standing Orders Act. Here, method, it says the same thing. If it is funded by the central government, then the central government is the appropriate government. And if it is funded by the state government, then the state government comes into play. The same thing is repeated here. Section 2A, my lord, may take up what is an appellate authority. So when this act came into place, my lord, into effect in 1946, so all the disputes arising out of insurance companies or banking companies, this was taken care of by this act, my lord. So section 2A, if I read, my lord, appellate authority, what it means, an authority appointed by the appropriate government by notification in the official gazette to exercise in such area as may be specified in the notification. And thereafter B, what is appropriate government means in respect of industrial establishment under the control of the central government or a railway administration or in a major port, mine or oil field, the central government, and in all other cases, state government. So where central government is not funding anything, my lord, then state government will come into picture. Am I clear, my lord? So this act was there, my lord, in 1946, it came into effect. So it looked after into all the banking issues, insurance issues, my lord, any dispute arising out of banking, insurance, all the industrial disputes, my lord. Now in 1949, another act came into place, that is, my lord, Industrial Disputes, Banking and Insurance Companies Act 1949, which I have provided a copy, my lord. I'll just read the preamble of that act, my lord. An act to provide for adjudication of industrial disputes concerning certain banking and insurance companies. So now it was very specific now. For insurance companies or banking, this act will come into effect, my lord. How it will come into effect, I'll just be reading the section 4, my lord. The preamble very well itself says that the act provided for adjudication of industrial disputes concerning certain banking and insurance companies, whereas it is expedient to provide for the adjudication of industrial disputes concerning banking and insurance companies having branches or other establishment in more than one state. Admittedly, my lord, I have branches pan-India, my lord, all over India, more than 1,300 branches. And my work is not confined or limited to the state of Assam. So thereafter, my lord, comes to section 4. This is the most important, my lord, which the learned tribunal has not at all, my lord, referred to. This has been misconstrued and misread, my lord. Section 4, prohibition of reference by state government of certain industrial disputes for adjudication, inquiry, or settlement. Notwithstanding anything contained in any other law, it shall not be competent for a state government or any officer or authority subordinate to such government to refer an industrial dispute concerning any banking or insurance company or any matter relating to such disputes to any tribunal or authority for adjudication, inquiry, or settlement. So it is very specific, my lord, that any industrial disputes concerning any banking or insurance company matter that may not be referred to by the state government or any employee working under it for settlement, for adjudication, or inquiry. And my lord, if my lord comes to next section 5, my lord, it goes one step ahead and says that abatement of proceedings relating to disputes pending before the state tribunals and reference of such disputes to tribunal constituted by the central government. So if any dispute was referred by the state government before the coming of into effect of this act, my lord, that will automatically stands abated, my lord. Where under any law, any industrial dispute concerning any banking or insurance company or any matter relating to such disputes has before 30th day of April 1949 been referred by a state government or any officer or authority subordinate to such government to any tribunal or any other authority for adjudication or settlement, and any proceeding in respect of arising out of such reference were immediately before the date pending before the tribunal or other authority, then the aforesaid date such reference shall be deemed to have been withdrawn and all such proceedings shall have abated. So after coming into effect of this act, my lord, that 1946 Standing Orders Act that effect was taken away, my lord. So now this act will look after into all inquiry, settlements, or disputes concerning banking and insurance disputes, my lord. The learned tribunal has failed to consider this aspect of the matter, which goes to the root of the matter. So my lord has seen that what is an appellate authority.
So this act comprises only this 2 pages.
2 pages, only 2 pages. Total 7 sections are there.
So this 1949 second ordinance is a repeal.
My lord. Yes, ma'am. Okay. So this is my sum and substance of my argument that, my lord, what is appellate authority, that is also given section 2B1 of the POS Act. What is where appeal has to be filed, my lord, who is an appropriate government. Appropriate government, if it is funded by the central government, then central government will come into the picture. If it is funded by the state government, then state government will come into the picture, my lord. And as
in case of private bank?
In private bank, my lord, RBI guidelines is there and it is funded by the central government. So we'll come under the
whether you are funded by the central government.
RBI, we are guided by the RBI guidelines, my lord.
No, it does not mean that you are funded by the central government.
But state government is also not there, my lord, in the picture. It's not funded by state government also. So how can
tribunal government may not be no, you may not be funded by the state government,
my lord,
but you are doing business within the jurisdiction of this tribunal, no?
I'm doing business within the jurisdiction of this tribunal, as well as, my lord, I have branches over other branches in India also, my lord, over different states also. That is why, my lord, that preamble portion that I read out, my lord, that where it is expedient to provide for adjudication of industrial disputes concerning banking and insurance companies having branches or establishment in more than one state. If I had a branch limited to this state of Assam only, then it would have been a different matter. But I have branches all over the India, my lord. So this industrial disputes, banking and insurance company, section 4 and section 5 specifically come into picture, my lord, which says that, my lord, if it is funded by the central government or it is under the central government, then state authority has no power to exercise any jurisdiction to refer any dispute.
Yes, Mr. Sakya.
My line of argument will be totally different.
Hmm.
If suppose the industrial tribunal in Assam is not having the jurisdiction,
Hmm.
then what is the appropriate forum in
Hmm.
which this appeal can be filed?
Hmm.
That has to be found out.
Hmm.
So I want them to inform this honorable court that which is the appropriate forum.
Hmm.
Their whole case is that industrial tribunal of Guwahati or Assam is not the appropriate forum.
Hmm.
In that situation, because I have done some research,
Hmm.
in fact, I agree that this particular industrial tribunal is not having the jurisdiction because a particular notification which was not placed by the other side, in fact, they should have filed it. So this, but only thing is that if it is under the state, then only this notification will be applicable.
Hmm.
This notification is issued by the Labor and Welfare Department.
Hmm.
In supersession, this is the notification of 2017, 7 January 2017.
Hmm.
In supersession of earlier notification in exercise of power conferred under Section 2A of the Industrial Employment Standing Orders Act 1946, the Governor of Assam is pleased to appoint a secretary to the Government of Assam Labor and Welfare Department as appellate authority to function in the context of the new act, that is the Post Act of 2013.
Hmm.
So our side also has made a mistake by going to the industrial tribunal.
Hmm.
They should have approached this, that the secretary of the Labor Department, because there is a standing notification.
Yes.
So let them say that suppose state government does not have the jurisdiction or the authority to take into account, because if we look at the appropriate government under the act,
Hmm.
then if we look at section 2B, the appropriate government under the Post Act of 2013, which says appropriate government means in relation to a workplace which is established, owned and controlled or wholly or substantially financed by fund provided directly or indirectly by the central government. So they do not have any central government funding.
Hmm.
Then the next B says by the state government, so that is the option.
Hmm.
And Roman 2 says in relation to any workplace not covered under subclause 1 and falling within its territory, the state government. So by A and B, we are none of the situation is covered to govern Yes Bank in Guwahati.
Hmm.
But Roman 2 gives that in relation to any workplace not covered under subclause 1 and falling within its territory, the state government. So that is only the territorial jurisdiction. It does not have to have any funding or control. So Yes Bank is not having any control by central government, number one, neither by the state government, nor Yes Bank is funded by central government wholly or partially, nor by the state government wholly or partially. So now, therefore, section 2B, Roman 2 covers the situation that state government is the appropriate authority. So if state government is the appropriate authority, then it is the Secretary Labor Department. As per this notification. So if they agree to that, we are going to ready. We are ready to go there. We have recently got a very favorable order also. Adverse inference has been drawn against them. But still, as an officer of the court also, it is my duty to point out this notification. This notification, after a lot of thorough search, we could get hold of this notification yesterday.
Okay.
Day before yesterday, I took time for 2 days. That's why I tried to find out what exactly is the missing link. Because the learned judge also, in that impugned order, has very clearly said notified by the state government. So where is that notification? That notification neither of the parties have placed before the court. So that notification for having the jurisdiction in industrial tribunal also, there must be a notification. That notification nobody could produce. Then when we searched with the Labor Department as well as our Judicial Department, this notification came to our hand. Therefore, from this notification, it is abundantly clear that the Secretary Labor Department has the jurisdiction of the appellate authority. If we read section 18, read with rule 11, this is the result. And if they want to say that central government, then where is the authority?
they have to produce that. But on either situation as contemplated under the POS Act. But they are taking recourse to that banking 1949 Act, that Industrial Dispute Banking and Insurance Companies Act 1949, Section 4. Prohibition of reference of the state government of certain industrial disputes for adjudication, inquiry, and settlement. So this is adjudication part. What about the appellate authority? We have to find out the appellate authority. There also they can have, otherwise, if we read this with the POS Act, we do not find out this situation.
Who is the appellate authority?
Who is the appellate authority? So if we read, conjointly read the provisions of the POS Act, read with this 1949 Act, as well as the Industrial Employment Standing Orders Act 1946. The notification is under this. And POS Act is a special act. Although the first line says, notwithstanding anything contained in any other law, it shall not be competent for a state government or any officer or authority subordinate to such government to refer to an industrial dispute concerning any banking or industrial company or any matter relating to such dispute to any tribunal or other authority for adjudication, inquiry, or settlement. Very fine. So if they want by dint of this particular provision that state government is not having any jurisdiction to consider any dispute relating to insurance or banking companies, then they have to indicate which is the appropriate authority. We have to go to some other forum. That is for sure because of this notification. So I would like to pray before this honorable court to give us an indication, because there was some gray areas till now. And as this is the Honorable Guwahati High Court Lordship, having jurisdiction of all the institutions here, pervasive jurisdiction. So in that view of the matter, some indication may be given to us, because in any case, the pending proceedings before the industrial tribunal will not be maintainable any further. We have to withdraw that. Otherwise, at the end of the tunnel in Supreme Court, the order will go against my client. Because on merit, we have a very strong case. Only the forum is a difficult proposition. And these are new acts, therefore, if the act is not very clear, because if you look, section 18. Section 18 mentioned about a court or tribunal, and if we look at rule 11, the word mentioned there is appellate authority. Let me place it. So section 18 says of the POS Act that 2013, any person agree from the recommendation made under subsection 2 of section 13 or under clause 1 or clause B of section 3 of subsections 3 of section 13 or subsection 1 or subsection 2 of section 14 or section 17 or non-implementation of such recommendations may prefer an appeal to the court or tribunal. So there is a mention about court or tribunal in accordance with the provisions of the service rules applicable to the said person, or where no such service rules exist, without prejudice to the provisions contained in any other law for the time being enforced, the person aggrieved may prefer an appeal in such manner as may be prescribed. So here we are taking the word court or tribunal. And if we come to the rule 11, 11 says, subject to the provisions of section 18, any person agree from the recommendation made under so and so sections or non-implementation of such recommendations may prefer an appeal to the appellate authority notified under clause A of section 2A of the Industrial Employment Standing Orders 1946. So here it is the appellate authority. So appellate authority should be a tribunal or court, and as in view of this notification, that particular designated person, he is the tribunal or the court. Just like in our taxation matters, quasi-judicial authorities they are having. By this notification, they are having that authority to act as a tribunal or act as a court. Only thing is that now, whether the Yes Bank comes under the domain of the state government or the central government. If we look at the language of the Post Act, very clearly it is with the state government's domain. Because that Roman 2 of section 2B very clearly says whichever organization or institution do not having any funding or control of the central government or the state government, then it will come under the domain of the state government. Following the regulations of RBI does not say, cannot mean that they are governed by central government. This is a wide imagination on their part. But only thing is that section 4 of this 1949 Act, in that situation, I would like to request the Yes Bank's authorities to indicate, because if they have to have an internal committee under them, the appellate authority also, they have to indicate to us. That cannot be the final authority. And if there is no such notification of the government of India to bring it under the domain of central government or under any provisions of the Industrial Dispute Banking and Insurance Company Act 1949, if there is no indicated appellate authority, then again the residuary provisions of Post Act will cover. That is 2 Roman B, Roman 2. So this is my humble submission, Lordship. That rightly or wrongly, Lordship, we have chosen a wrong forum to file the appeal against the recommendation of the internal committee. Now it has come to our light. So it definitely will take the corrective measures, corrective steps, because we do not want adjudication, a prolonged adjudication in a wrong forum and later on to be found out that it is not the right forum, not having the jurisdiction. We want to avoid and preempt that situation. Because by flouting all principles of natural justice and all principles of any sort of trial, without any evidence, without any materials, the finding is given. So I have to have some recourse of remedy. If all the roads are closed, then 226 is the door for me. So if they fail to indicate that which is the appropriate forum, okay, fine. I also accede that Industrial Tribunal of Guwahati is not the appropriate forum. Fine. Then what is the alternate way? Because when we say a particular case before this honorable court, they have an alternative remedy. What is that alternative remedy? They have to indicate. Otherwise, I would like to request this honorable court to give us a way so that we can at least knock the door at the right forum. If it is a central government authority, we'll go there. If there is no forum, they have notified because they are representing Yes Bank. So Yes Bank must have a complete structure from the first stage to the last stage. The first stage is the internal committee, and that act under which they have acted upon, that Post Act, that act indicates there should be appellate authority. So the structure of the state Yes Bank must be very clear. The roadmap should be clear so that any of the employees, suppose the recommendation of the IC came in my favor, the person who lodged the complaint, she should also have a forum to go for a proper adjudication. So that should be indicated because Yes Bank is a neutral body. The IC is a particular wing of that authority to test the veracity of the complaint. And they found something against me. It could have been the other way around also. But in either way, the aggrieved party have a right to go and challenge the recommendation. Where is that forum?
Okay.
Finding no way, we went to Industrial Tribunal. Now we are at least honest before this honorable court that the forum was wrongly chosen because this notification could not be found out by the appropriate authority, by the learned court also, and by the parties also, and till today the other side also. So that is my humble submission. If required, Lordship, I will make my further submissions subject to what they say.
You have obtained instruction?
My lord.
We'll list the matter on Friday then.
Yes, Lord.
Friday?
Right. As admission, my admission.
There was a part hard going on.
Yes.
If it comes in order, my lord, it will come last. That's why.
Okay. Heard Mr. Iqbal, learned counsel for the petitioner, and Mr. D. Surke, learned senior counsel assisted by Ms. T. Barua and R. Barua. For the respondent. Heard in part, list the matter on Friday.
Deeply offensive.
Obliged, madam.